Justice of the Appellate Division, Supreme Court, First Department. He, no person such as this is the Appellate Division, on here, give your attendance and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, September 16. So as you probably know, those of you who have been here before, those of you who have not been here before, we have approximately 8 hours of argument time requested. Obviously, we would not be able to do that. So I'm asking that you please ask for the time that you actually need in order to get out the salient points of your arguments. We have read your briefs. We are fully familiar with your arguments. People v. Ronaldo Andino. I'm sorry? 525. Solis v. City of New York. Solis.
Respondent requesting
525. Matter of Christine.
Good morning, Justices. Respondent requests 1 minute.
Sanchez v. 1562 Barrett Avenue.
Appellant, 5 and 2, please.
Respondent, 5 and 2, please. Thank you.
You have a cross appeal? Did you have a cross appeal? 5, 2, and 5. Farrell v. Stove Properties.
Good afternoon, Your Honor. Appellant, 6 and 3. Respondent requests 10.
Okay, 5, 2, and 5. I'm getting feedback. Thank you. People v. Jeremiah Martinez, there are 2 appeals, and both are submitted. Fine Creative Media v. Barnes and Nobles. You have a cross appeal?
Yes.
5252. Green Tree Servicing v. Rivera. That matter is submitted. People v. Romeo Carrion. That matter is submitted. Homelink International v. Law Offices of Sanjay.
Good afternoon, Your Honor. Appellate 5 and 2.
Respondent, 5 minutes.
525. People v. Jose S. 525. I am recused on that matter. The rules of this court is that if there is a tie, another judge will be vouched in. Madam Gloria?
Respondent requests 5, Your Honor.
There's no appellant.
Correct.
3 minutes. Thank you. M. Ngwali v. Department of Education of City of New York. That matter is submitted. Fernandez v. Sukdeep. Apologies. Matter is submitted. People v. Jorge Lewis.
Request 5 and 2, Your Honor.
Respondent requests 5, Your Honor.
525. People v. Chad Hooks.
For the appellant, 5 and 2, please.
Respondent requests 5, Your Honor.
525. Freedom Kia v. New York State Department of Health.
Yeah, good afternoon. Appellant requests 5 and 3. I believe there would be 2 respondents, so just like yesterday on the file.
Respondent number 1.
State respondents request 5 minutes, Your Honor.
Respondent appeal 3 minutes.
5 and 3, 5 and 3. Alibaba Hotel v. Pros.
Good afternoon, Your Honor. Appellant requests 5 minutes and 2 for law, please.
Respondent requests 5 minutes.
525. People v. Orellana. That matter is submitted. Acevedo v. Citibank is submitted. Wayman v. CPE Housing Development is submitted. New York State Division of Housing v. Zara is submitted. First matter for argument is People v. Ronaldo Andino.
Step up.
Yes, you may proceed.
Good afternoon, and may it please the court. Nupur Sen from Cleary, Gottlieb, Steen and Hamilton, pro bono counsel for Ronaldo Andino. This case is about the police conducting an illegal search pursuant to an invalid warrant. The police's warrant was
Counsel, if there was a valid waiver of the right to appeal in this case, does that foreclose your argument on the search warrant? Not the search warrant, rather, on the no-knock provision?
if there was a valid waiver, Your
Does it
Honor.
foreclose your Fourth Amendment issue?
There was not a valid waiver here, Your Honor, and the people aren't contending that there was. In fact, they conceded this argument. It's on pages 3 and pages 9 of their brief. They're not relying on the appeal waiver here. And I'm happy to get into the appeal waiver further if you would like, but it's not. an
Continue
issue.
with your argument.
Thank you. The police's warrant here was invalid for 3 reasons, but the first and most important is that the police acted in reckless disregard for the truth and misled the magistrate judge.
How did they mislead the judge?
They misled the magistrate judge, Your Honor, by presenting to the judge that Craig Andino, a man who was incarcerated at the time, sold the drugs to their CI. They misrepresented that Craig Andino resided in the apartment that was listed in the warrant, and they further misrepresented that Craig Andino was likely to be found at that apartment on the day of the search, when in fact, Your Honor, on the day of the search, on the day the police applied for the warrant, and for months before that, Craig Andino was in fact in prison.
Did the police know this?
I can't say whether they knew it, Your Honor. That's really for them to say, but they certainly should have known it. Because as you'll see, Your Honor, on the first page of the police's affidavit, they put the Craig Andino's New York State identification number, which is, kind of the social for if you've had criminal history.
He was a target of the investigation, but the apartment, the premises were also a target of the investigation. Weren't the premises a target?
That's correct, Your Honor. But what the defense counsel is presenting here, Your Honor, is that the story that was presented to the magistrate judge was one that was inextricably entwined with Craig Andino.
But the allegations underlying the request for the search warrant was that a number of buys had taken place in that apartment. So why was that not sufficient to establish the probable cause necessary for the search warrant?
Your Honor, because when those buys took place, the police presented to the CI a photograph of Craig Andino. They say in their brief, Your Honor, that the CI didn't know the person selling him the drugs by name. So it was in fact the police that put forward a photograph of a man who was in prison at the time to the CI. The CI then ID'd that man as Craig Andino, and the police presented to the magistrate judge that it was that man on both occasions.
But the warrant was not necessarily issued because this person was Craig Andino, but because there was drug selling taking place from that precise premises. Because the confidential informant with whom they had previously worked and had provided accurate information in the past had gone there on a couple of occasions and purchased drugs.
That's right, Your Honor, and I'm not arguing about the credibility of that informant. What I am saying is that the police's own conduct here is what was in question.
But the informant went before a magistrate and under oath stated, I've been to the premises, I purchased drugs, and the last time I was there was 5 days ago.
And half of the story that the magistrate judge had concerned who sold those drugs to that CI. Did that person live in that apartment? Well, that
But
Go ahead.
if they get the search warrant and then they go to the premises to execute the search warrant, the people who are inside the premises at that time, would they not also be part of whatever's executed if there's drugs found there? Would they not be caught up in that?
Respectfully, Your Honor, what we're saying is that we need to take a step back in time to the moment when the police applied for the warrant. And what could they have reasonably believed at
So
that
at the time that
and
they
what-
applied for the warrant, they had information from the CI that he or she had purchased drugs at that location. Then the officer went to that location, checked it out, determined that that was the apartment that the CI was referring to, and applied for the search warrant. So why, again, is that insufficient?
The officer verified that an apartment was there, Your Honor. What the officer did not verify is that the person that the officer was suggesting sold the drugs, and the CI
Why
was
would that
agreeing as-
matter? Why would that matter when you're talking about a location? And as my colleague mentioned, you know, once they went to that location, so long as the location was verified as per the search warrant, once they go to that location, the quote-unquote target or the person who had actually been selling drugs doesn't have to be at the location. Whoever is at that location would be subject to arrest if in fact that there's drugs found at the location.
But the problem here, Your Honor, is that Craig Andino's name appears 18 times in the space of roughly 6 pages of their affidavit. So we can't say anymore that this warrant was really just about an apartment and whoever was in there, because they chose to rest their story.
So again,
not just the apartment.
if this individual, again, the individual was not at the apartment, so you're saying because this individual was not at the apartment, then the individuals who were in the apartment were not subject to arrest?
I'm saying that the information that the police put in front of the magistrate judge misled the magistrate judge.
So you're saying that it wasn't reliable information? It wasn't sufficient to get the search warrant issued?
Exactly, Your
What
Honor.
if it didn't say the person's name? What if it just said this confidential informant went multiple times and has recently just bought drugs there?
That is a world that could have existed, Your Honor, but that is not the world we're in.
And so again, and my colleague, I think, asked this initially, is there anything in the records to suggest that the police were aware of the fact that this individual was incarcerated and was not actually the person who had sold the drugs from the apartment?
Respectfully, Your Honor, the standard for reckless disregard for the truth is knew or should have known. I can't say that they knew. There's nothing.
So the answer to my question is no. And the answer to my colleague's question was no, right?
The
Is that correct?
answer to both of your questions, Your Honor,
Is no.
if I may, is they should have known.
And why should they have known?
The reason they should have known, Your Honor, is because they had access to his NICID. They put it on the first page of the affidavit, and it takes roughly 60 seconds to check that NICID against the police records. It's an online search or one phone call, and they could have told that he was in fact incarcerated.
Do you know how many times bench warrants are issued for individuals that happen to be incarcerated when they don't show up in court? Have you ever heard of that?
You can think about that and respond on rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Nathan Morganti on behalf of the people. The search warrant was supported by sworn testimony from a confidential informant and two controlled...
And that CI indicated that they knew who Craig Andino was, and that's the person who sold them the drugs. Why isn't there a problem there with probable cause? Craig Andino was incarcerated.
Well, Your Honor, without getting into the sealed record, which I'm going to try to stay away from, the informant did not know the name Craig Andino. He knew the person selling him drugs by a false name that is in his testimony in front of the magistrate judge. And that's why there's not a problem with probable cause here, because the informant was operating on the information that he had at the time, and he did testify in front of a magistrate judge, making his statements presumptively reliable. But even if we look beyond that, we have the police conducting not one, but two controlled buys. The police searched the informant, found he wasn't carrying drugs. He went into this apartment building, went to the apartment in question, according to his testimony. Someone came out whose name he did not know, and he bought drugs from that person, or I should say he did not have the correct name for, excuse me. And he bought drugs from that person on 2 occasions. And then after that, the police went and confirmed that that apartment existed where the confidential informant said it was, and only then did they apply for the search warrant.
And what happens when a search warrant is executed and there happen to be other people in a location where drugs are found?
Well, of course, Your Honor, those people will be subject to arrest as well by virtue of the drugs being found in that apartment. But we actually have more here if Your Honors were to look at the record. When defendant is being arrested, when the apartment's being searched, he says that there's drugs and gun, or there are drugs and a gun in a closet over there.
But also, the drugs were found on his person, were they
Yes,
not?
there were several drugs found on his person. I don't have the exact number in front of me, but it was...
I think 56 bags of crack cocaine.
That is what
on
I-
the defendant's
that is what-
person and a weapon from the apartment.
Yes.
But then we'd be putting the cart before the horse, because if there's insufficient cause to justify issuance of the warrant, we can't get justification for that by what they find based on an invalid warrant.
Of course, Your Honor, and we're not relying on that, but that is just to show that once the apartment was searched, the defendant was then arrested and searched pursuant to finding drugs and guns in that apartment, which makes this arrest valid.
So at the core of Aguilar Spinelli is we want to make sure there's reliability behind the CI.
Correct, Your Honor.
And so does it undermine the application at all that it turns out a name was used for the occupant consistently, and then it turns out that person was incarcerated the entire relevant time?
I don't believe so in this case, Your Honor, because the CI testified. That makes his testimony presumptively reliable, and obviously, if the CI had been lying, he would have opened himself up to fines and penalties in that regard. So I don't think that the Aguilar-Spinelli concerns are at play here.
Well, your friend argues that the police should have known that the individual was incarcerated because all they had to do was simply check that information, and if they had checked that the NICID, they would have found that the individual was incarcerated.
Well, that may or may not be true, Your Honor. We don't know what NICID was even showing at that time if they had searched it. So I think that's kind of outside the record and shouldn't even be looked at. But even if they did, as one of Your Honors pointed out, this can be a mistake that happens a lot. A bench warrant can be issued for someone that's in jail. The NICID system isn't perfect, and then asking police to kind of do this check in every circumstance would be overprotective.
Well, not only the NICID, but is there any obligation on the police to verify that type of information?
To verify...
Did the person exist, that the person just exists or is not incarcerated or is not somewhere else?
Well, there
Do
may
any type of investigation concerning the individual named?
I don't think there is in this circumstance, Your Honor, because of the testifying confidential informant and the fact that drugs came from someone inside that apartment. They weren't just spontaneously produced by knocking on the door. So that gave the police probable cause to search then that apartment and anyone found inside with those drugs.
So you, in your papers, you state that you're not going to, I forgot what the exact words were, but basically you're not dealing with or addressing the waiver issue.
We're not relying on the waiver here, Your Honor. Obviously, case-by-case decision that our office makes. We obviously believe that the waiver was voluntary, but as we mentioned in our papers, this court's decision in Francisco seems to be very close in facts to this case. And then just very briefly, if I can just address the overbreadth and vagueness claims, no court in the state of New York has ever said that you need to define where in an apartment you need to search. The Court of Appeals has held that, this court has held that, and that's with good reason. There will be absolutely no way for police to know that until they're actually inside the apartment, seeing what interior doors are locked, where people can access. And in regards to the no-knock warrant, the evidence set out in the warrant application specifically mentioned small, easily disposable drugs for sale. The warrant application mentioned that when the CI bought drugs, he bought small quantities, and it also established that there were many ways to destroy those drugs.
Thank
you very much.
Thank you, Your Honors. Just a few points quickly on rebuttal. The first is, as you correctly pointed out, the relevant timeline here and the relevant facts are not what happened in the apartment, who was there, what was found in them. We need to zoom in and look at the time frame of when the police applied for their warrant, what they knew, what they should have known, and what they told the magistrate judge. That is the relevant time frame. The second piece, Your Honor, is my friend here talked a lot about the confidential informant. The confidential informant testified under oath. We're not alleging that the confidential informant was not credible or lied under oath. We're saying the police's course of conduct here was questionable. The police acted in reckless disregard for the truth, and that is why the warrant was invalid.
But if the confidential informant told the court, the magistrate, the same thing they told the police, and you find that what he told, he didn't lie to the judge, then he didn't lie to the police either.
If we take a step back in time, Your Honor, the police showed the confidential informant not once, but twice, a photograph of a man that they should have known was incarcerated at the time that the buys occurred. That's the step the police took. The police presented to the confidential informant the likely seller of the drugs, a man who could not possibly have sold the drugs. That's the nub of the issue here, Your Honor.
So you're stating that the confidential informant's testimony was inaccurate as well?
I'm saying, Your Honor, that the police's affidavit contained material inaccuracies.
Right, but my colleague asked concerning the testimony by the confidential informant. And confidential informant made statements before the issuing judge. So are you also arguing that the confidential informant was inaccurate or lied or misrepresented the truth somehow?
I'd be out of my depth there, Judge, because I don't have access to that transcript. That portion of the record is sealed and defense counsel doesn't have access to it. So I don't want to get into questions of the CI's credibility. But what I can confidently say is that the police had at the tip of their fingertips the information they needed to know that the man they said sold the drugs could not possibly have sold the drugs.
Thank you. Thank you both, and thank you and your firm for allowing you to do this pro bono, right? Thank you very much. We appreciate it.
Pleasure. Thank you.
Solis versus the City of New York.
May it please the court, Lauren O'Brien on behalf of the City of New York. Summary judgment should have been granted to the city here because there are no facts from which a trier of fact could conclude that this could find the city liable.
So how do we know who's liable? The video shows the decedent leaving the facility with the cane.
Correct.
And then at some point in time, apparently, we don't know when, right? He no longer had the cane and he fell down the stairs.
Right. So what we have here is the city officials ensuring that the decedent had his cane up until the moment that he left Rikers. We don't know, and then the next time we hear about the cane is the fact that he didn't have it with him when he was descending the staircase.
Exactly.
But at that point,
Michelle asked him what happened to your cane,
Right.
and he says they took it.
but he doesn't identify who took it.
Exactly.
And at that point, he's in state custody. He
But
is-
also, however, the court officer's testimony that was submitted in support of your motion indicates that when he left DOC custody to OCA custody, there was no cane.
I'm not familiar with anything in our witness's testimony that suggested that he didn't have his cane when custody was transferred from the city to the state. There, on my read of the record, there is no evidence in the record about what happened to the cane.
Mangino was that witness, right?
So Mangino was the state official. This is a state officer, the state court officer who escorted him down the stairs after his court appearance.
Did you
So that-
submit Mangino's testimony in support of your motion?
We did, but his testimony is only relevant to what he could only recall even seeing Mr. Solis after his court appearance.
Right, so he
wasn't
said
even
that
necessarily the officer that brought him up.
He said that he did not remember if he went down to DOC to take custody of the decedent. He
Correct.
believed that the decedent was brought up by another officer, and he knew that he escorted the decedent down the staircase
That's
to
correct.
the 12th floor.
And at that point, there doesn't appear to be a dispute that he didn't have his cane at that point. And I believe that that officer testified that he couldn't remember whether he knew if Mr. Solis needed a cane at that point.
So
And
he
doesn't remember
testified that he testified that the decedent did not have a cane when he was transferred from DOC to the pens in the courthouse. That's what Mangino said. He didn't know.
He said he didn't know. And
Okay.
he said he didn't remember whether he was the officer who received the transfer from corrections, that he just remembered that he was the officer that escorted Mr. Solis down from the court appearance. And I just want to emphasize that
I
Mr.
thought he
Solis,
testified that he did not have a cane when he was transferred from DOC to Part 82 pens.
He did not.
That's what, on record 718.
He did not. He said that the decedent did not have a cane when he was transferred from DOC to the Part 82 pens. Record 718.
But what about the fact that he had a boot on his foot and he had difficulty walking? What about that just as the fact that he's in custody and he's clearly has this issue?
right, so at the point that he's at the top of the stairs and he's in state, not city custody, it is correct that he had a boot at that point. We have the report from the other inmate who was with him saying that he was having difficulty walking and he didn't have his cane. But the point is that there are no facts to connect what happened after that
Well, that's the
point
whole
to
point. We don't
anything.
know what happened to the cane. So
Right.
as we all know, or many of us know, an inmate is transferred from the facility to the building. Then the handoff from DOC to the court officers, right?
Correct.
So you have Mangrino testifying that he was not the one who actually went down to pick up the decedent to bring him up, right?
Correct.
However, when the decedent was brought back down, that's when he fell and he did not have a cane.
That's correct.
So we don't know what happened to the cane from when the decedent left Rikers, was on the bus, brought to the building, brought up to the courtroom, right?
Correct.
We don't know what happened to the cane.
don't know
All
what
we
happened
know
to
is
it.
that when he went down the stairs, he didn't have the cane.
That's correct.
So how do we know who took the cane? How do we
So-
know that it wasn't the city who
Right.
took the cane, DOC, as opposed to OCA?
The
and
fact that
UCS?
we don't know, what happened to the cane means that the plaintiff has failed to establish a theory of causation that's based on anything other than
But this was your
speculation.
motion
Right.
for summary judgment, right?
Correct.
And the
it's
witness
well as-
that you submitted, Brown, the DOC witness, only spoke in general terms of what this is our general policy of what we need to do, what we usually do. But there's nothing specific other than that video that shows that when he left the facility, he had the cane. But there's nothing like when he was on the bus. There's no specific testimony from the driver or from any escort that says, well, he still had his cane, and when we dropped him off, he still had his cane. There isn't that. I mean, so there's deficiencies for you in meeting your burden.
So if I may, I just have two responses to that question. I see I'm out of time, but my first response is that the Court of Appeals said in Gale versus City of New York that it is the plaintiff's burden to render alternative causes of an injury sufficiently remote so that a jury doesn't have to speculate what the cause was. So it is ultimately the plaintiff's burden. And this court has repeatedly says that where a defendant can show that a plaintiff's theory rests on speculation, that is sufficient for the defendant to make out their prima facie case.
Well, is it speculation, or is that just a lack of sufficient information, sufficient facts as to exactly what occurred?
Because there are no facts, the trier of fact would have to engage in guesswork. They would have to just guess what
So
happened.
your argument is that we're speculating that DOC was responsible for his not having the cane.
Correct.
Why is it not the flip side that we're also speculating that UCS also was not responsible for his not having, the cane?
Well, I would just emphasize that we have very specific testimony from the city's witness saying that the city's consistent practice is to ensure that an inmate has his cane anytime he has
Is
walked.
practice enough, though?
In contrast, we have no such specific practice.
So you're relying
or
on
policies
habit
the
and
part of the
custom.
state.
Habit and custom, right, of the DOC?
Consistent practice and custom, and in contrast, the lack of any evidence of any similar specific practice or custom on the part of the state. In
I
fact,
think we've said in Belding that habit and custom evidence only allows for the fact finder to draw the inference that the practice was followed on the date in question. It doesn't provide a basis for summary judgment as a matter of law.
But again, here, it is the plaintiff's ultimate burden to support a theory of causation with something more than just speculation.
That's assuming you meet your burden, right?
Are you saying that you met your burden simply by showing that video where he is seen with the cane as he's leaving the facility?
By submitting the video showing the city complying, in fact, with the practice that was described by our witness's testimony, doing exactly what he said the city does, and then also by submitting evidence of the city's practice and pointing to the lack of evidence, explaining what the state's practice is
But
when
again,
they
that's,
receive.
it's a long ride from Rikers to 100 Center Street, and he's on the bus. And again, we don't know what happened to the cane, and I don't see that you've presented anything that would tell us exactly what happened to the cane. And we have Michelle, who's stating that, the decedent told him they took it. Who's they? You have time on rebuttal.
Thank you.
Good afternoon, and may it please the court. My name is Gene Baradelli. I'm here representing the respondent, the estate of Appellate Solis, who is asking the court to affirm the trial court decision denying the city's motion for summary judgment. Having listened to the panel, I think that what the court is really talking about is whether or not the city has shown entitlement to summary judgment based upon this theory of mere speculation. But what the city hasn't shown is that in order to be entitled to summary judgment, there has to be only one conclusion that can be drawn from the undisputed facts that are contained in the record. That can't happen here because, as the panel has been discussing, as we sit here today, we still don't know where this cane is. What we do know...
Why isn't it enough for them to have shown that he came back from having the surgery, they supplied him with the boot, they supplied him with the cane, when it was time for him to go to court, he was put on, leaving the facility with the cane, and they've met their obligation. They provided him with this medically necessary apparatus.
Because, Your Honor, the Department of Corrections responsibility doesn't end when they leave Rikers Island. There is an entire intake process as well. If you recall from the record, the trial court decided that summary judgment should be denied on two different grounds. The first ground being there's an issue of fact as to whether the accident was reasonably foreseeable given the facts and given what the city knew about Mr. Solis's actual medical condition. The second reason is because the city has a self-imposed duty, and it appears in a directive created by DOC, Directive Number 3802, which charges the officers in taking those arriving from Rikers to be identified to whether or not they have a disability or not. And as the court has already pointed out, he was wearing a post-op shoe. It's not like a cam walker that you would think of. It's like a softer shoe that he would be wearing that would give a little cushion for the ambulation of the decedent. And at that point, the city had a self-imposed duty to check on Mr. Solis to see if he needed reasonable accommodations. Had they done so, they may have found out that he had a cane with him when he got onto the van. And at that point, they would have been able to accommodate him, whether it be to have him walk slower, to have him not have handcuffs while he's walking.
Well, he wasn't cuffed as he was coming down the stairs, right?
Correct. That was a decision by the state officers.
Exactly. He wasn't cuffed. The only thing missing was the cane. So no one was holding him. He could have held on to the handrail coming down the stairs, and he didn't. And the question is, what is the practice which they say that they followed? If somebody has a cane, according to the witness, the correction witness, they would allow the person to have the cane at all times. According to the OCA witness, if the inmate had the prisoner had a cane, he would be allowed to walk into the courtroom with the cane. What we know is he left the facility with a cane. He boarded a bus with the canes, supposedly, right? And then he fell down the stairs because he didn't have a cane. Where would somebody have taken that cane away? Or did he simply left it?
Well, if we believe the testimony of the deputy warden about their practice, we would know that when he is on the transport between Rikers Island and Manhattan Criminal Court, he would not be allowed to have his cane. And we saw that in the video as well, Your Honor.
Right. They would, while he's on the bus, they took the cane away from him and they put the cane at the front of the bus.
Well, that's what they say that they do.
Right.
There is no evidence, no testimony, no documentation showing that the cane made it off the bus,
right,
Your Honor. So unless the city can show that they fulfilled that duty, knowing about his medical necessity for the cane, then they should not be entitled to summary judgment as to the issue of foreseeability.
So the only folks that would have taken the cane away from him would have been DOC.
That's correct, Your Honor, because DOC is responsible for the care, custody, management, and control of the inmate. When he is moved, they tell him to move. When they have him go into a holding cell, they put him in the holding cell. They take his cane away when he's not moving. They're supposed to give him his cane when he is moving. Unless they can show that they fulfilled that duty, then there's an issue of fact concerning.
And all this is on the record, or this is just argument that you're making now?
Well, this is all based upon the habit and practice that is testified to by Deputy Warden Brown as to what happened, and based upon what we saw in that practice being done at Rikers. There's no evidence, Your Honor, that this practice was being done at MCC when he's getting off the van.
Thank you.
Thank you, Your Honors.
I just want to respond by emphasizing that there is no evidence that he lacked his cane at any point before custody was transferred to the state.
But what the question that was asked, I think, before, have you met your burden by simply saying, we don't know who had the cane, when, according to the argument that I'm hearing, and matters in the record, he would not be allowed to have the cane on the bus?
So
how do we know that that somebody gave him the cane after he got to MCC?
it was the stated policy of corrections to hold the cane at the front of the bus and then return it to the inmate once they arrived at the courthouse.
So do you have an affidavit from whomever it was that was on that bus on that day that can say, we gave this person his cane?
So we acknowledge we don't know what happened to the cane in between the time that he arrived at the courthouse and when he fell.
Well, not only in between when he arrived at the courthouse, also when he was after he got on the bus. We don't know what happened to the cane after the cane was taken from him and placed at the front of the bus. After that, we have no idea what happened to it. We don't know if the cane ever made it off the bus. And I think my colleague asked earlier whether you had an affidavit from the bus driver or someone on the bus who stated, from corrections, who stated, as he was getting off the bus, we gave him the cane.
We don't, but I do just want to emphasize that this court has repeatedly said that a plaintiff's case can't rest merely on speculation, and where a defendant can show that there are no facts to support.
It's not, their theory isn't speculative. Their theory is, I had a medically necessary cane, and I didn't have that while I was ambulating downstairs. So it's not that he's speculating on causation, it's we don't know whose negligence, if either parties deprived him of that cane. It's not that we have to, we're speculating as to the cause of his slip and fall, it's that we just don't know which actor, if either, deprived him of the cane.
Well, regardless, because of the lack of facts in the record, a trier of fact would just have to guess.
But I think maybe the thing that is missing for me is that DOC would be the perfect people or entity to describe what in fact happened once he boarded the bus with that cane. That information is directly within DOC's purview, and that is what is missing here.
And that is what I think you would need in order to make a prima facie case.
Thank you. Thank you both.
Thank you, Your Honor.
Thank you, Your Honor. Matter of Christine. Yes?
Good afternoon, Justices, and may it please the Court. Michael Weinstein on behalf of Ms. Christine B. We ask that this Court affirm Judge Cooper's order, which had a sound and substantial basis in the record. Specifically, there was significant testimony concerning the trauma that the child had endured at the father's hands. Rather than leave Mr. G without any visits, Judge Cooper did grant visits twice weekly, therapeutic visits. Whether they're workable or not, which is not part of the record itself, because the child doesn't want to go to them, there is case law specifically that says it's actually not a violation of the court order when the child makes that decision.
And the visits are not conditioned on the child wanting to
Correct, correct. And had they been, there might be a claim on appeal, but here there isn't concerning the visits. As to the second point that appellant raises concerning 251A of the Family Court Act, that the family court can issue a mental health evaluation in any proceeding of any type that's relevant. That issue was not preserved in the court below, and we ask that this court affirm Judge Cooper's decision.
Thank you.
Thank you.
Rafael Sanchez with Herod Avenue.
May it please the court, your honors, Michael Gleason for the appellant. The facts of this matter are straightforward. The plaintiff claims to have slipped and fallen in paint chips.
So the plaintiff is claiming notice, is that correct? That he notified the defendant of the condition?
No, he vacillated throughout his entire deposition. I complained. I made a complaint.
Well, let me just
may
ask this
not
question.
have.
I
And
was
then-
reading the record. I did not understand because I've never heard of anyone painting a bathtub. I thought you glazed a bathtub. And I thought when you glazed a bathtub, I don't understand how you would get paint chips from glazing a bathtub.
That's 100% accurate. The documentary evidence was that the bathtub was glazed. The plaintiff used the term painted.
But in the no one corrected him to say, look, when you glaze a bathtub, you're not going to get any paint chips.
Well-
And he also testified that there were so many paint chips that his wife had to sweep them up periodically.
Well, but he also testified that I didn't tell the building. Maybe his wife had to sweep it up, but he didn't tell the building.
He said it was a recurring condition. I thought he said that he had told the building.
And that was the issue, is he vacillated the entire deposition. So finally, at the end, the questioning attorney sat down, and I can read you the testimony, and he said, listen, I'm not trying to trick you. I'm just trying to get an accurate timeline here. You said you made complaints on multiple occasions. Let's talk about it. And he ultimately came to the testimony that I made a complaint, and the building sent someone, and they corrected it.
Right, so he said that he complained to the super 1 year before the accident, and the super painted the tub in response. After the paint started chipping again, he again complained to the super.
But then he corrected his testimony later on, and it said, I'm not trying to confuse you, Mr. Sanchez. You just testified that you made 2 separate complaints before March of 2021, which was the date of the accident, about the condition of the tub. What I'm asking is whether or not those were before or after the painting. Like I said, this is the answer. Like I said, before the accident, I complained, and they sent someone to fix a little something. Then after the accident, I complained, and that's when they sent someone again.
So from the time that they painted the bathroom before your accident up until the time of your accident, did you make any complaints? No.
Correct. So the fact of the matter is, he admitted that he never made any complaints about the condition of the tub, or his version was up to 1 year prior to the accident. It also has to be emphasized that he says 2 days prior to the accident, nothing in the tub. The day before the accident, nothing in the tub. I'm stepping in the tub. I don't see anything in the tub.
I thought he testified that 2 days prior to the accident, he saw paint chips. Was that on record 89 to 90?
Yes, before 2 days. And then he said within 2 days prior up until. But he admitted that, so it would have been the 3rd day before the accident. So we're semantics. But the 3rd day before the accident, and said, well, did you tell anyone at the building about this? And he goes, no.
What about that the medical record said he was drinking at the time, and that's in the summary judgment motion? Is that germane?
I'm sorry?
In the medical record that he was drinking at the time?
Correct. And the fact is, that was 4 days after the accident, his first medical treatment. He went to the emergency room at St. Barnabas Hospital, and he said, I was drinking in the shower and I fell. He testified, well, they're lying about me. They're lying. They're making up this. It's throughout his records. There's no indication in the medical records that I slipped on paint chips in a bathtub.
Well, I don't think
I
that
was
would be
drinking.
admissible anyway, right? What caused him to slip in a bathtub isn't germane to medical treatment and diagnosis.
Well, on its own, however, the Court of Appeals has said when a plaintiff is speculating as to the cause of the accident, if there are viable other ways in which the accident could have occurred, you can't go forward with this. And the simple fact of the matter is, from 2 days prior until 1 month after the accident, he admits that he never saw paint chip. There was no testimony that, oh, I felt them under my feet at the time.
But he said his daughter saw stepdaughter saw paint chips during that time. A month after the accident, she still saw them.
That's complete hearsay, and it has absolutely no relevance because he even admitted When I got out of the tub, put on my towel, still didn't see any paint chips, went into my bedroom, got ready for dinner, watched TV. My stepdaughter comes by, and I said, I fell. On what? Or, excuse me, she said, I fell. She goes, be careful. Be more careful. There was no discussion from him saying it was on those pesky paint chips that are always there. There was no discussion whatsoever. It was 2 days prior through 1 month post.
Thank you.
Good afternoon, Mike Cremens, Raskin and Cremens for the respondent.
So can you tell me how we get paint chips from glazing a tub?
Well, first of all, as far as, I can't tell you, I'm not an expert with regard to paint chips, but I can
Do
tell
we
you.
need an expert? Does somebody need an expert to say that you don't get paint chips when you glaze a tub?
First of all, they said there was painting in the tub, okay?
He said painting. The record shows that the tub was glazed, and we have the name of the company, the American Standard Glazer Corporation.
This was a ongoing.
Reglazed the plaintiff, reglazed, 2018, they reglazed the plaintiff's tub.
Whether they reglazed it or painted it at that time, whether it was a private company or whether it was the super, there were paint chips that existed in that tub subsequent to that time.
So, counsel,
there were complaints that were made.
that's my question about the complaints. Like, post the glazing, painting of the tub, can you just point in the record, because his testimony is kind of all over the place, can you just point in the record as to where he notified anybody of this reoccurring condition?
He testified that he told the super 2 days before, 2 to 3 weeks before this occurrence, that there were paint chips. He, in fact, saw the paint chips 2 days before. There's no proof that anybody took any action to remove those paint chips. A jury could reasonably infer that those paint chips were there at the time when he fell. And so I think that based upon the credible evidence here, a jury could certainly find that it was the recurring, ongoing condition of that tub with these paint chips that caused this incident. I don't believe that defendants have met their burden. They have the burden here on summary judgment. Yeah, the fact that he's a senior citizen and with medical issues and he didn't testify perfectly at his deposition, I'll concede that. And
well, it's not that it's not that he didn't testify perfectly, but the question was, so from the time that they painted the bathroom before your accident up until the time of your accident, did you make any complaints? He says no.
That's correct. And later on in the deposition, when
no, that was later on. That was later on in the deposition. It was earlier in the deposition that he said that he had complained about 8 months prior.
Right, and that was subsequent to the painting or glazing of the tub. So the landlord, the defendant, was on notice of this recurring condition that.
Well, here's the thing. He testified in his deposition that he didn't make any complaints. First he said, okay, it was 8 months before. Then he said, no, he did not make any complaints. Peralta, the superintendent of the building, states that no one complained to him about any paint chips or anything else in the tub, regarding the tub, after it was reglazed.
According to Peralta, there was never any complaints of paint chips at all. So why glaze or paint the tub in the first place, just to make it whiter? Obviously, a jury could come to the conclusion there were complaints made, and this was the landlord's attempt to remedy those complaints instead of taking action and either doing a new tub or putting something safe in, to just kind of just put a Band-Aid over it. And there was complaints subsequent to that glazing or painting.
Counsel, are there pictures of this? I didn't see any pictures of the tub.
There were pictures taken at the deposition. I do not know if there were pictures in the record.
There were pictures referred to during the deposition?
Yes, there were pictures during the deposition. They
I
were,
didn't see any exhibits of any photographs of the tub.
I believe defendant marked those as exhibits. I could look at the transcript again, but I believe they were marked defendant's exhibit A, B, pictures of the tub. But just if I could stress the fact that some of what counsel said, as far as whether he was intoxicated, whether or not whatever he told his daughter, that's all for cross-exam. That has nothing to do with them meeting that burden as far as what he told people after the fact, what he told, and there's no admissible, even the medical records aren't in admissible form, but that's something, I believe, for the trial, not for summary judgment here, but based upon the burden that the defendants have here, I don't think they've met it. They say plaintiff is speculating. No, there was complaints before the glazing or painting. There were complaints after that. We know there were complaints made just 2 to 3 weeks before this incident of these paint chips that were slippery, and he even slipped at that time, but he caught himself. 2 days before, he saw the chips still there. There is no testimony that those chips were ever removed by anybody.
So the chips just stayed in the tub. So people just continue to bathe or whatever in the tub with the chips in the tub. Although the wife testified that she would clean the chips from the tub, that she would sweep them up.
Sometimes she would. That's sometimes she would. But
Thank you. Did you submit photographs at the deposition of the tub?
There were no photographs from the date of the accident that were a part of the motion.
Were there any photographs whatsoever of the tub?
I think there were photos from months after the accident.
With paint chips?
They weren't a part of the record, but...
So why was the tub reglazed in the first place?
Well, and that's what I wanted to address. There was no testimony from Peralta that there was nothing wrong with it. We just wanted to make it shiny white. There was a complaint that was made about the condition of the tub, which was 3 years prior to the accident. They hired an outside company to come and reglaze it. His file...
What was the condition? Chipping paint?
But I don't know what the condition was, but I would assume that the tub needed work. So they hired a company. For 3 years, there were no further complaints. And we produced the record that this non-party came in and corrected the tub, and there were no further complaints. And when counsel claims...
Counsel, because I was just going through the deposition testimony again, at one point around record 203, 204, he says that he complained to the super about 3 weeks before, but then later on, maybe I think this is page 207, the question is asked, quite frankly, after they painted the tub, did you make any complaints? And his answer is no.
Well, and at 203, it was even clarified because we didn't let it go. And when you made a complaint about the paint chipping, what specifically did you tell both the super and the office about? That's the testimony you're referring to. I told them the bathtub was peeling and the water wouldn't drain. Question, you don't recall when that was made though, correct? Answer, no. So he admits, on one end, he says, I made complaints, but you don't know when you made them. And then he ultimately settles in, as you noted, on 207, saying, essentially, yeah, I made a complaint before, it was corrected, nothing was done up until the date of the accident, or excuse me, nothing was done ever until a month after when I made another complaint.
So is that enough to not defeat your motion for summary judgment where you have to show that you did not create a recurring condition?
Yes, because when the non-party corrected the condition, the presumption is that it was corrected properly, and the plaintiff cannot serve as his own notice witness when he doesn't notify. It's a private bathroom. This isn't a stairwell. This isn't the front of the courthouse where the super would constantly go by. As I cited a case, Judge Ramser in Supreme New York, and she said, there's no duty for a building to go into someone's bathroom and look for these conditions. You have to tell them. Absent complaints, documented complaints, you can't establish notice. And with the super's testimony that we didn't receive any complaints, the plaintiff's testimony, that he ultimately settled on, I didn't make any complaints from anywhere from 1 to 3 years prior to the accident. We established a lack of notice upon the building. And it shouldn't be glossed over that this is pure speculation. You know, for 2 days prior through 1 month post, he was in his house for 3 days after the accident, sought no medical treatment, sat there, presumably bathed himself, did not see any paint chips. There's no testimony that, well, I was on my hands and knees in the tub after the fall. For how long, sir? 2 minutes. No chips. He
Thank
didn't
you.
see chips.
Thank you both.
Thank you.
Farrell LLC v. Stove Properties. What did I do? I asked you if you had a cross motion, you said no. You didn't have a cross motion? No. Thanks again.
Good afternoon, Your Honors. Glenn Lenahan with Oved & Oved LLP on behalf of appellants. After leasing the premises at issue here for over 9 years without any leaks, water intrusion, or other disruptive incident, one day out of the blue, the tenant discovered that there were severe leaks in its premises originating from the building's roof. Tenant notified the landlord repeatedly, asking landlord to fix it. Landlord failed to do so despite its obligations. Within a few short weeks, these leaks created so much damage to the premises that it was rendered unusable, the tenant was constructively evicted, and it caused hundreds of thousands of dollars of damage to the tenant's possessions and business. Pursuant to the lease's clause in Article 12, the tenant terminated the lease because it had been rendered unusable by virtue of the landlord's failure to make a required repair. It surrendered the premises and paid all rent due as of that date. The landlord refused to accept that termination. Tenant then commenced this action for declaratory judgment that it had properly terminated the lease and also asserted claims for breach of the lease, breach of the covenant of quiet enjoyment leading to constructive eviction, and creation of a private nuisance. Independently, each of these claims would provide an independent basis to terminate any potential future rent payments that the tenant might owe to the landlord. The landlord moved to dismiss the complaint based on 3211A1 and A7 of the CPLR.
How does section 12.10 of the lease apply to your argument? Or does it apply?
It does apply, Your Honor. It provides that if the premises are substantially damaged by a fire or other casualty that occurs during the last 18 months of the lease, either party may terminate this lease by giving notice. And if either party terminates the lease by giving notice, the lease will terminate as of the date set forth in that notice.
Is casualty defined somewhere else in the lease?
No, it's not. And in fact, it's really not clearly defined in case law anywhere, as the Second Southern District noted in a recent 2021 case. The issue we have here is that—
Has this court ever had the opportunity to interpret what a casualty is?
It is, and this court has interpreted to mean a sudden event or unfortunate occurrence leading to, creating substantial damage.
And is that what occurred in this case?
I would argue yes, Your Honor, because the leak originated from one point in the roof of the building, which wasn't part of our premises, made its way down into the premises, and immediately, within a few weeks, rendered the premises completely unusable. So we believe this is at least a question of fact as to whether or not this is a casualty.
Well, the tenant claimed that it had discovered multiple leaks originating from the roof.
The roof of their premises, so the ceiling of their premises had multiple leaks.
Right, and then there were new leaks forming all throughout the premises.
Which all had its genesis on a singular leak in the roof. But yes, Your Honor.
I just want to bring you back to the case law, because I know that there have been times when this court has interpreted a casualty as a fire, some kind of sudden event. And then there have been times when we said leaks or recurring water intrusions are not. Where does your case fall in that spectrum?
Towards the fire, Your Honor. This wasn't, for example, the case in, Blue River, I believe it is, Blue Water Realty. In that case, this court found on summary judgment on a fully developed record that a recurring leak was not a casualty. But what's distinguishable there is in that case, all the witnesses said, oh yeah, every time it rains, it leaks. This has been going on for years and years. That's nothing like the situation here. We have a tenant for 9 years, over 9 years in a premises, where every time it rained, they stayed dry. There weren't any leaks. There wasn't any issue. Here, because of this leak in the roof that was created by whatever reason, it led to catastrophic damage within just a few short weeks. And we believe that is at least a question of fact as to whether or not that would constitute a casualty.
And then in Andreas versus 186 tenants, we held that a recurring water intrusion is not the type of sudden event contemplated by the proprietary lease.
Yes, that's right, Your Honor. And this case doesn't go, the court's opinion in this case doesn't go deep into what was going on, what actually was that recurring water leak. And I agree that a lot of times a recurring water leak will certainly not be a casualty, but I don't believe that it can be in every single instance when it manifests itself in such a short period of time. There's also the issues of the other claims that we still have, the claims for constructive
We'll get to those in rebuttal. Thank you.
Thank you very much, Your Honor.
May it please the court, I'm Norman Flitt. At counsel table is Laura Rahab, who helped on the brief. This case simply rests on the express provisions of the lease and on a pertinent precedent, the Blue Water case. Justice Weber, you were on the panel for that, and that's the case that we cited. They try unsuccessfully to distinguish. A recurring water leak is, as a matter of law, not a sudden cataclysmic event, certainly not a fire.
Well, is this a recurring water leak when for 9 years there was no issue and then all of a sudden now the roof is leaking in another part and causing damage?
You know, 9 years doesn't matter. And I go back to Blue Water. There was a stipulated settlement there, and they were dealing only with a leak for a few years. Here, a sudden event. Okay. What was the sudden event? December 18th, they write, landlord, we have a subtenant we want to get out. December 21, this is 2018, they write, we have a leak. We immediately get on it. The record is clear. It's their own exhibit with the emails. And one after another, we do things for them. And it just goes on and on and on. Now, they can't fit within 1210, which frankly is the only provision, it's the only way they can get out of their pre-existing obligation under Article 3.1 of the lease, where they're responsible for the lease rental from day one through the end of the term. Day one through the end of the term. And 3.6 of the lease expressly limits no offsets, no abatements, nothing, unless you get it from the lease. So they had a situation, and they had one way out, if applicable. They tried unsuccessfully to take it. They wrote a notice under 1210, and frankly, since 2013, they were trying every which way to get out from under this lease. And it's apparent from the correspondence and what we were doing, we had a roofer and this and that and back and forth. They didn't want us to fix the thing. They were delighted to find a way out, and Justice Leibowitz said, no, this is not something as a matter of law that triggers it. And, you know, the Blue Water case in the Appellate Division, they reversed your decision, Justice Mendez, below, where you found, like they want this court to find here an issue of fact based on the same kind of thing. A leak is a leak, but it's not a cataclysmic event. And every single case in this area, you mentioned Andreas, Blue Water, there are others. And
does it matter how much time it takes the leak to cause this catastrophic damage?
Okay, I'm going to answer it. It does, because if it's a let's say a pipe burst. Let's do a proper example. Like that Atlantic case that Judge Leibowitz on re-argument said, you know what, you're right, Flitt, I shouldn't have relied on it. So that was one example bang, it happens on day one under 1210. You got 30 days limited, 30 days to notify the landlord that you're exercising your termination right. That 30-day requirement is inconsistent with what they're saying should be included in this clause. And let's talk about their claims. They made a choice. In fact, this case is about choices. The lease mandates choices when you want a rent abatement, and they can't make it under 1210, and no other provision. And there's similar provisions to the provisions as is, repair, you don't get an abatement. You get X number of days for this condition and that condition, it can work out. They didn't want it to work out. So their claims, first one for a declaration that 1210 was correct and they did it right. Gone, matter of law. The other three are damage claims. They sought $400,000, which I say in my brief is about 2 times the amount of rent that was left for the lease. And you know that tenants, if they can, and by the way, I should emphasize, 12.9 is the clause, express agreement to the contrary, that allows only the limited remedies there. You can't go to common law, you can't bring a claim for constructive eviction. And Justice Leibovitz said, you know, in the re-argument order, where is the claim for constructive eviction? It's not here.
Thank you.
I'd like to address a couple things, and I want to start with the last thing my colleague said. Section 12.9 of the lease says that this article shall be considered an express agreement governing any case of damage, capital D, damage. Damage is defined on page 64 of the record to mean any damage caused by fire or other casualty. If this isn't a casualty, then 12.9 doesn't apply, which means our common law claims apply. And breach of the covenant of quiet eviction, breach of the covenant of quiet enjoyment leading to constructive eviction, along with creation of a private nuisance, both of which are in this case, were not dismissed, were not asked to be dismissed, which Justice Kennedy upheld when they made their motion to dismiss. Both of those say, if you are constructively evicted for one of these reasons, you don't have to pay any more rent. The landlord's position here is, yes, your property was horribly damaged because of my negligence and failure to make a repair, but too bad, you got to keep paying me rent, and there's nothing you can do to get out of it because this wasn't a casualty. Fine, if it wasn't a casualty, then it's not barred by the lease necessarily, and our other claims, which have not been dismissed because they didn't move for summary judgment against the landlord at all, and which is why all of these other facts that you're hearing from Mr. Flitt are not in his brief because they're not in the record because they never produced discovery. They wanted to avoid discovery, so they moved immediately for partial summary judgment on the guarantee alone. When Justice Leibovitz denied it, they still didn't produce the discovery. They moved to re-argue and said, no, Atlantic Holdings bars this, even though Atlantic Holdings said this water leak, in that case, is a casualty, and didn't say anything else about what is not a casualty, which is why re-argument shouldn't have been granted in the first place. But even if this court has concerns about whether these leaks, which were of an enormous magnitude, occurred in a very short time and ruined the premises, are a casualty or not, it doesn't matter because our other claims are still in the case and the guarantor cannot be liable until and unless they have established that there's an underlying debt owed to the landlord, which has not been done because of the existence of the breach of the covenant of quiet enjoyment leading to constructive eviction and the creation of a private nuisance which led to constructive eviction. Thank you.
Thank you both. Fine Creative Media v. Barnes & Noble. Yes, please proceed.
May it please the court, Karen Dechter for Appellant, Fine Creative Media, which I'll refer to today as FCM. FCM's appeal asks this court to reverse the portion of the trial court's ruling that dismissed its fiduciary duty claim, breach of the implied covenant, and contract claim under Section 11C. I'll start by addressing the fiduciary duty claim, which is based on FCM at Barnes & Noble's behest, establishing an entire new business to co-produce an in-house classics line for Barnes & Noble, the Barnes & Noble Classics, which grossed hundreds.
In order for there to have a breach of a fiduciary duty, or for there have to been a fiduciary duty, do you not have to show that this was, or at least plead, that this was a joint venture?
We do, Your Honor. And
So how was this a joint venture?
the trial court did not take issue with us adequately pleading 3 of the 4 joint venture elements. The trial court dismissed the breach of fiduciary duty claim solely because of the alleged failure to plead loss sharing.
Right.
But this court has made clear that you may dispense with the requirement that co-ventures expressly provide for loss sharing where there is a plausible inference that there was no reasonable expectation of losses. And that is the situation here. By the time the parties entered into the 2003 agreement, which is at issue, the Barnes & Noble Classics were already a proven success. The majority of the advances under the earlier agreement had been paid back. And indeed, it was this remarkable success that prompted Barnes & Noble to agree to expand the venture.
What losses would FCM have incurred in this joint venture if it didn't work out? What would have been your losses?
Sure.
Because we know you made a lot of money, but what were your losses?
Sure, and this is the fundamental error with the trial court's decision. The trial court said that the parties risked losing their initial capital investments in the venture, and that was enough to show a reasonable expectation of loss. But then when FCM pointed to its allegations in the complaint showing how both parties shared that risk, FCM risks losing its entire investment in a business infrastructure that it created to service the venture. Indeed, that's what was borne out.
Is that all that FCN did? Print books for the classics for Barnes & Noble, or did they do other type of publishing or printing for other entities?
For purposes of this agreement, they leased thousands of feet of office space, hired an entire new team of employees and contractors. This was a very significant investment that was undertaken.
Was that something that was known or anticipated at the time that you entered into the agreement? In terms of these third parties?
It was expressly, so I just want to make sure I understand the question in terms of which third.
You mentioned that there were potential losses in terms of third parties. Was that anticipated at the time that you entered into this agreement with Barnes & Nobles?
The only real potential obligation to third parties was the rent obligation, and that was expressly provided for in the agreement, that it would be shared, I believe, 67-33. The other reasonably expected losses were the investments in the venture, which are necessarily one-sided injections. And that's why Justice Freed in Dundee's, a case with facts remarkably similar to this one, a co-publishing venture that netted profits, where the sole expectation of loss were the parties' potential losses in producing and developing this interior design book.
The Barnes & Noble paid the startup costs?
So as pleaded in paragraph 18 of the amended complaint, they did advance a portion of the development costs, but that was not.
And they would be obligated to pay royalties even if books were not sold? Is that correct?
FCM was obligated to pay back those royalties, those initial advances, excuse me.
So would there be an obligation to continue to pay forever, given this? Would they just have to continue based on your interpretation of this joint venture?
So could I...
Was there a time when they would be able to stop ordering those books?
So could I imagine a hypothetical where the parties, for legitimate good faith business reasons, decided to walk away? I could imagine, but that's not what's pleaded here. What's pleaded here is the venture was highly successful. Barnes & Noble was acquired by private equity who made the decision that it wanted to usurp the venture for itself. It looked at what the best-selling titles were. It quickly created replacement versions of those titles. It then repurposed positive reviews of the Barnes & Noble classics while stopping to stock them in stores to divert all the business to this new replacement line so it could usurp the venture for itself. We plead.
You have time on rebuttal.
Good afternoon. My name is Linda Steinman from Davis Right to Maine, and I'm representing Barnes & Noble.
So what your friend just mentioned in terms of the things that Barnes & Nobles did, I did not, is that in the record or is that argument on her part in terms of all these things that you did?
There's a multi-page agreement here, which is the basis of the district court's decision. That agreement lays out the essentials of the transaction. Under this transaction, Barnes & Noble paid FCM when the books were delivered. If the books did not sell, Barnes & Noble alone bore the loss.
But FCM, according to their position, they leased property to facilitate this business between the two of you. They didn't have that before, but once they entered into this agreement, that's how they were going to make all of this happen. Why isn't that a loss, or is that just the cost of doing business? That's just a risky loss.
Exactly. Every supplier has to pay some money to create the goods. They have to rent some space and manufacture the goods. That's not necessarily a joint venture. As the Lebedev case says, what the most indispensable requirement of a joint venture is the parties agree to share the losses. Here, that's not how the transaction was structured at all in this lengthy agreement.
Who would bear the cost of the losses? Who?
Barnes & Noble entirely. So the books get delivered, Barnes & Noble has to pay for them. The books don't sell, Barnes & Noble fully gets stuck with the loss. That's why it's not a joint venture. There's no undertaking to share the losses.
Did this agreement have an end date? I know
So this agreement did not. It had a minimum purchase requirement, which was both an enormous protection for FCM. We had to buy 2 million books, but it was also an off-ramp for Barnes & Noble. After we satisfied the minimum purchase requirement, which was years and years ago, we could stop purchasing them, and that's what you want. You want Barnes & Noble to be able to have a new owner who comes in and says, you know, I don't think these books are so good, they're stale. They were created in 2020, 2003. It's now 2020. We want to serve our customers better. We would like books that have more beautiful covers, that have better printing, that have better introductions. That's what we want as a public policy matter. And instead, FCM has come to this court and said perpetually, if Barnes & Noble publishes Jane Eyre or Wuthering Heights, I want to be paid a massive royalty, even though there's nothing in our agreement that says that has to happen. Barnes & Noble all along was publishing Jane Eyre and other versions, including leather-bound collectibles, the Sterling Unabridged Classics, and then at a certain point in time, after it hit the minimum purchase requirement, it said, you know, these books are not what our customers deserve and want, and so we're going to stop ordering, and we're going to have better books. And it went out and created beautiful covers and beautiful paper and French flaps and sold a different product. It was entitled to do that. Let me also answer directly their question, their comment, that there was no expectation of loss. They had an initial agreement, and they published 40 books under that agreement. It went fairly well. But then they decided to significantly expand this to 250 titles. They paid a much higher advance, $3.2 million. They expanded to real estate. And so the fact that a pilot project had succeeded doesn't in any way forecast that this enormous project would succeed. In their own complaint, they do not allege that there was no reasonable expectation of loss. In fact, they attach an article from 2003 in the New York Times that said that Penguin Classics and Oxford Classics had occupied this field, and it was a very risky venture for Barnes & Noble to start publishing public domain titles because there was such intense competition in that area. So The complaint itself admits there was a reasonable expectation of loss. Lebedev goes on and on and on how it's the very rare exception where the plaintiff doesn't need to prove an expectation of loss, and the burden is on the plaintiff to show there was no reasonable expectation of loss. Let me also say that Amazon, the presence of Amazon, caused tremendous havoc in the book publishing industry. Borders went bankrupt, many bookstores closed. This is just like Lebedev. Lebedev said that the oil market is a volatile industry, the book publishing and selling market is a volatile industry. So
ebooks as well.
Ebooks as well, exactly. Let me also turn momentarily to the contract claims. I would encourage this court to dismiss the claim under 8F as well. Their proposition coming to this court is wholly illogical. Why in God's name would Barnes & Noble agree to pay them a hefty royalty every time it published Jane Eyre in series that had absolutely nothing from them? Not their covers, not their introductions, not their reader's notes. So I will sit down now. I see my light is red, and return shortly.
Thank you.
So much of what my friend just said is outside of the record and outside of the pleading and outside of the agreement, and that's precisely why.
The question was asked, what was the end date on this? Is it your argument that this was going to continue forever?
So I think this is exactly where Zilg v. Prentice Hall is instructive. Even without a best efforts clause and even without an end date in that agreement, I believe, the court said you still have an ongoing obligation to exercise good faith. We say even in a higher duty under the fiduciary duty, but even under the implicit covenant of good faith and fair dealing. And in Van Valkenburg, the Court of Appeals said there comes a point in time where another party conducts themselves in a way that's so manifestly harmful to the other side that it may plausibly plead a breach of the implied covenant. And that's what we plead here. Barnes & Noble on summary judgment and in discovery can try and make a case as to volatility in the industry about Amazon or whatnot, and that they did in fact exercise good faith. But from a pleading standard here, we've met the element, A, that there were no reasonable expectation of losses, because at the time, the agreement was already very, very successful, and the only potential losses were the parties' contributions, one-sided contributions to the venture. In Fat Brands, the Second Circuit held that there was no reasonable expectation of loss and dispensed with the loss.
How was this one-sided?
Well, to the extent that FCM bore all production and development costs, and I think just how much of a risk they bore is shown by what happens here. When Barnes & Noble breached their fiduciary duty, their duties—
But my colleague mentioned in the beginning, you made a lot of money on this venture.
FCM was forced to shutter its entire business after Barnes & Noble was acquired by private equity and made the decision to cut them out. This was a situation where Barnes & Noble held exclusive rights to exploit the books. It's not as if FCM could take all their investment and the line and go somewhere else. They were at Barnes & Noble's complete mercy. And Barnes &
But you didn't own the books. You didn't own the books.
This was a joint venture to go in to create an in-house classics line, specially.
So then the answer to the question is, if there was an end date, just based upon what you're saying, is like, no, this was going to go on in perpetuity.
To the extent, and that's the claim that Judge Cohen allowed to proceed, to the extent that Barnes & Noble wanted to continue on this highly successful venture, it owed a duty to partner with FCM on that. There might have been some good faith business reason why Barnes & Noble, they might be able to prove this on summary judgment as to why they could walk away. We say no, it was motivated in bad faith.
Could you have walked away?
We would have been in breach of the contract.
Thank you.
I was just going to say that Barnes & Noble was going to buy all of those books. And as your colleague or your friend said, if everybody decided to buy it on Amazon, they weren't going to Barnes & Noble. Isn't Barnes & Noble running the risk here?
So,
because they're going to keep those books. They're not giving those books back that are unsold.
So I think it's important to keep in mind that the purchases were in very small quantities. That was something that Barnes & Noble negotiated so it could really minimize and FCM could help cushion that risk, since FCM bore the entire production and development costs, affording Barnes & Noble extraordinarily high margins and allowing them to purchase in very small quantities, which was at great expense to FCM because of paper and printing costs and allowing them to do so. This was a situation where they jointly agreed on pricing, jointly agreed on titles, jointly agreed on rent obligations for this office space. FCM wrote Barnes & Noble hundreds of thousands of dollars.
So what was the response to my colleague's question?
I think I lost the thread. I apologize.
It's okay. Thank you.
Thank you.
Briefly, Your Honors, my argument is based solely on the terms of the agreement and on the complaint. The complaint itself says the B&N Classics were aimed at competing directly at publishing heavyweights, such as Penguin Classic and Oxford Classics, which already had a hold on sales of classic books for use in classrooms and colleges. In February 2003, the New York Times wrote that the stiffest competition in the book business may be among the many publishers staking claims to Dickens, Austen, Herodotus, and Plato. There were certainly potential risks here. Second of all, I don't understand this reference to small quantities. The Barnes & Noble had to buy 10,000 copies of each title. Of course, there was a possibility that those 10,000 copies would not sell. The implied covenant. The implied covenant is not there to create new obligations in a contract. These were sophisticated parties. It is a many-page agreement, single-spaced, parties represented by counsel, and the cases provide that for the implied covenant, there has to be some specific statement in the contract, and then the court makes sure that that specific promise is executed in good faith. So, for instance, in the TWA case, there was an obligation to publicize the other party's tours so that enough people signed up for the tours. And the court said that obligation had to be exercised in good faith because it was in the agreement. The provision that we have to pay advances to them for a perpetuity for Jane Eyre, there's nothing in the contract that they've drawn that from. Okay, turning to Section 8F of the contract, that was the one area where the judge below was hesitant to grant summary judgment. Our briefs explain that it is fine to dismiss a claim if theirs is not a reasonable reading. I would encourage the court to look at the Goldman Sachs versus Almond case, which says that if you have an introductory clause and then many, many examples, you have to look at the examples in terms of interpreting the provision. If Barnes & Noble was going to agree to this unusual proposition that it would pay royalties in perpetuity, it certainly would have said that in plain English and not buried in a clause that talks about e-books or leather-bound editions of the work. Thank you very much.
Homelink International v. Law Offices of Sanjeev Rabi.
Good afternoon, Your Honors, and thank you for providing me this opportunity to argue my own case pro se before this panel. Your Honor, this case arises out of a sublease between appellant and respondent. Sublease was entered on January 2020. Just after execution of sublease, 2 months after that, pandemic happened. An entire country, federally and state-wise, was under lockdown on 17th of March. Your Honor, being a solo practitioner, my office was closed for a prolonged time due to COVID. And at or about October 1st, 2020, sublessor terminated my lease.
So you stopped paying rent in March of 2020.
Yes,
And
Your
then
Honor.
you vacated in November of 2023.
Yes, Your Honor.
And so they are seeking unpaid rent from March 2020 to November 2020.
Yes, Your Honor. They filed, even commenced a landlord-tenant action, Your Honor, which was commenced on December 1st, 2020, after termination of the lease. And then on October 17, they made a request to the judge for issuance of warrant. Not only their request for warrant was denied by judge also dismissed the underlying petition, which is on record. Civil court denied the petition and dismissed the petition. On record, it is a detailed
So
decision.
you were opposing the assignment of the lease, right?
Your Honor, I'm not opposing just the assignment. I'm saying that now the HomeLink International Inc. has no standing to commence this action on various grounds. First is, Your Honor, once the first case was still pending, they had dissolved the corporation on August 16, 2023. They had dissolved the corporation. Once they dissolved the corporation, they had no ability even to apply for issuance of warrant before the L&T court. Either they were misrepresenting, or they were negligent, or they were not aware of. After that, not only they didn't appeal that decision, or they filed any review on that, they filed another action on the same issue, on the same ground of non-payment in the same court, Your Honor. And at that point of time also, HomeLink International LLC, the dissolved corporation, in 23 commences another action. Then they realized that this commencement may be wrong, and they filed a motion to substitute HomeLink International Inc., which is a foreign corporation in California, to substitute. This is the first time the tenant gets a notice that the corporation is dissolved, and there is an assignment, alleged assignment. Your Honor, we filed a cross motion to dismiss complaint.
So where in the record, or where did you establish that this was a foreign corporation?
Your Honor.
That could not do business here in New York?
I have done, Your Honor. Not only I have stated that in my affidavit and affirmation, but this is also on record. I will draw the attention of this court on the second non-payment petition which was filed, Your Honor. They themselves have attached it as exhibit there, and that is at page 73, 75 to 78 is the article of dissolution and resolution approving the dissolution of HomeLink. It is, I would rather say 75, 76, 78, 79, 80. And these are the exhibits provided by us, by the respondent. These are not my exhibits. I had no knowledge about this. Now, Judge, that lawsuit was when they realized that this is also going to be dismissed. As a strategy, they filed a motion to withdraw that complaint, although we oppose that because we have been I'm a solo practitioner and I have to take care of my other cases rather than my own case, Your Honor. But judge granted a specific permission to file a plenary action just to the LLC, not to the Inc.
So was that the one of the proceedings that you did not appear at? Was that the proceeding you didn't appear?
Your Honor, that was a 3-day notice. On July 3rd, this was motion. I called the other side to seek extension because I was.
But the answer to my question is yes. That was the proceeding you did not appear.
Yes, Your Honor.
Okay, you have time on rebuttal. Thank you.
Thank you.
May it please the court, my name is Channing Turner from Schlom, Stone & Dolan for the respondent in this case, HomeLink International Incorporated. First and foremost, if the panel has any questions for me, please, I'd love to address those this time. If not, I'll...
Do you just at this stage, at this pre-answer stage, just have to raise an issue of fact as to standing?
It is the defendant's burden to raise an issue as to standing before we have any affirmative burden to put forth any evidence in this posture on motion to dismiss. And so the answer is no, we have no affirmative duty.
The defendant's alleging that the substituted company is a foreign corporation. What's your answer to that?
It is. It's a California corporation. The original landlord in this case was an LLC, HomeLink International LLC. The plaintiff in this case is now HomeLink International Incorporated. It's a corporation. This corporation was the sole member of the LLC. And it's true, as well as has been stated, that the LLC was dissolved. However, upon dissolution of an LLC, its members then are explicitly authorized by statute to wrap up the LLC, including bringing suits like this one for any liabilities owed to the LLC.
And does it matter then that the foreign corporation status, does that matter at that point in bringing the lawsuit?
Well, as I understand it, there's an argument being made by the defendant appellant that foreign corporations cannot bring a lawsuit in New York State Court unless they've registered. And that's true. However, the statute that's being referenced requires that there's some proof that the foreign corporation is doing business before there's any obligation for it to register. So it has to be shown that the corporation is doing business in the state of New York before it then has an affirmative duty to register with the state.
Well, that's under the business corporation law is what they're asserting, is that under that business corporation law, I think, what is it, 13? Yeah, 1312 subsection A, it would preclude you from bringing a suit.
That's correct. But only if the corporation is doing business in the state is there an obligation to register.
Right.
In this case, we were a member of an LLC. Now, the LLC was doing business in the state, and it was registered. But now the LLC is dissolved. We're statutorily authorized to bring suit on behalf of this dissolved entity, and we've not been...
In order to wrap up the business and also to collect any monies that are owed the LLC.
Correct. And so the point is, HomeLink International Incorporated, the plaintiff in the suit, is not doing business in New York. It never has. It is merely wrapping up the, whatever needs to be wrapped up on behalf of its LLC.
And also, a reference was made to 2 prior non-payment proceedings.
Correct.
And the argument is that it constitutes res judicata.
That's my understanding of the argument, obviously.
And your response?
My response is that neither the discontinuance, voluntary discontinuance, nor the dismissal on the basis of failing to move for default within 1 year, neither of those were made with prejudice. Neither of those was a decision on the merits. There is no bar to us reasserting our claims in a plenary action for monetary damages as we've done here. Unless there's anything else, I'll finish there. Thank you.
Thank you.
Honorable panel, 3 important points I want to make for the consideration of this panel. One, that respondent mentioned that it was a sole ownership of both the corporation and the Inc. Whatever the nomenclature of Inc. or corporation was, the proprietor was same and he was doing business or she was doing business already by virtue of extension of their interest in New York. So registration is important as per BCL 1312. Secondly, Your Honor, we have to also understand that what CPLR 1021 provides. That provides that previously, before amendment, it was a reasonable time a party will substitute. But now it very clearly says within 4 months of the event. I have quoted the law. The event took place on 8/16/23, Your Honors. And the first time the motion was made to substitute was 3/14/24, after lapse of almost 7 months. And this lawsuit, the third time I am put to test, is filed after 11 months of dissolution. Once a corporation was dissolved, who had got the authority to file even substitution on behalf of that corporation? I believe no, it's like a dead man's case. The corporation was dead. Inc. did not move the substitution. Still the LLC moved the substitution. So even the basis of substitution request at the second case was also wrong, was baseless, invalid. Thirdly, Your Honor, what is the subject matter of first landlord-tenant petition? It was recovery of unpaid rent. What was the second L&T petition? Non-payment, recovery of rent. And between whom? Same parties, Homelink and law offices of Sanjay Chaubey. Now the third case is what? Recovery of rent. Between whom? Homelink and Sanjay Chaubey. I do not know what extension of res judicata, same parties, no new ground or no new theory has been presented by respondent in their third lawsuit.
Thank you. Thank you both.
Thank you, Your Honor.
The next case is People v. Jose S. Again, I am recused on this matter.
Okay.
Good afternoon. Rebecca Besden with the Office of the Appellate Defender on behalf of Jose Soriano. Mr. Soriano's counsel failed to investigate 2 independent witnesses to the shooting, whose accounts would have contradicted the sole prosecution eyewitness to the shooting, who claimed that Mr. Soriano was the shooter, and would have powerfully corroborated the defense theory, including Mr. Soriano's own testimony, that Stephen Valle was the shooter and acted alone.
The people proceeded also on an acting in concert theory. If these 2 witnesses had come in and testified the way that you're putting forth, would that have supported that acting in concert theory, or would it have helped out your client's testimony who said, I wasn't even there?
It absolutely would have supported the defense. So this testimony that Valle was the shooter, again, would have contradicted the sole prosecution eyewitness, whose account was that Mr. Soriano was the shooter. So this would have entitled the jury to discredit his account, leaving no direct evidence of guilt. And this is especially true where the prosecution eyewitness's account was already contradicted by the forensic evidence and was actually impossible according to the forensic evidence. On the other hand, Mr. Soriano's defense, and he testified to this, was that Stephen Valle was the shooter and acted alone, and that while Mr. Soriano was present in the vicinity, he walked away, he had no intent, did not assist in any way, did not know anyone was going to be shot. So these witnesses would have corroborated the heart of Mr. Soriano's testimony.
Would they have placed him at the scene or not?
So they described, I believe it's 4 male Hispanics present, not assisting in any way. So it's possible they could have placed him at the scene, but mere presence, as the court knows, is not enough to establish accomplice liability. So
Is he on video running away? What looks like a gun, putting a gun and then in his pants and running away?
So the video is subject to multiple interpretations. The shooting does not happen on camera. The shooting happens off camera, and the events immediately before and after are shown on video. So Mr. Soriano actually narrated the video in his testimony, and his testimony was entirely consistent with the video. The prosecution had another interpretation of the video, and this again comes down to this being a credibility contest where these witnesses' testimony would have been so pivotal.
Now, did Mr. Soriano admit in his testimony at trial that he did receive the gun from Mr. Valle?
Yes, so his testimony was that he didn't know anyone was going to be shot. He walked away. Valle ran towards him and said, I shot them, I shot them. Mr. Soriano said, who did you shoot? They're right there, seeing the other people present, and that Valle thrust the gun at him when that happened. So again...
Which he picks up and then he runs away with it.
Yes, and of course the gun was recovered ultimately on Valle's person after he fled the state with the murder weapon after the incident, whereas Mr. Soriano voluntarily reached out to the police that morning. But just another quick response is, again, Mr. Soriano's testimony did deny any accomplice liability, any participation, but to the extent there were some concessions about other portions of the incident in his testimony, had the defense had access to independent, credible witnesses consistent with the forensic evidence that would have discredited the prosecution theory, he may well not have elected
Could those witnesses have said that Mr. Soriano was not one of the 4 individuals that they saw when the shooting was taking place?
I don't want to speculate about what they would have said about that because, again...
They were an interview, right?
What?
We don't know.
Exactly.
Because they were an interview, at minimum. Maybe.
Exactly.
But did they say that they could not recognize the faces of any of the individuals? They could not see their faces. They only,
yes,
they
I
could only
believe
describe
they
their
did say
clothing.
that. Yes, that's true.
So they could not say whether Mr. Soriano was one of the 4 individuals that was with Mr. Valle when the shooting took place.
Yes, that's what it looks like. Yes, I would agree with that.
So if we take it one step further, the people's theory of acting in concert, these witnesses did not have much to offer on that specific theory. They could say the shooter was the person dressed in black, but they couldn't say that the other people that were around the shooter were not acting in concert with the shooter.
Yeah, their testimonies just describe, or their statements to the police describe a lone shooter unassisted by any individual and other people merely present at the scene, which does not make out accomplice liability. And of course, their accounts would have contradicted the testimony of the only prosecution eyewitness, which would have entitled the jury to discard it in its entirety, leaving no direct evidence of guilt, which again is especially true considering that the prosecution witness claimed the shooting took place at a distance of at least 20 feet, whereas the medical examiner said that stippling meant the gun had to be within 18 inches of the decedent.
Okay.
So it was already impossible according to the prosecution's own evidence.
Any questions? Thank you.
Good afternoon, Lori Farrington for the respondent. These 2 witnesses had absolutely no information regarding the theory of acting in concert under which the defendant was indicted.
I mean, you have police witnesses, detectives who go out and interview, they're doing their investigation and they come up with these 2 names of these individuals. The names are listed in the DD-5s and that information is turned over to counsel. And counsel doesn't even go and talk to them, whereas he could make a decision as to whether or not they had anything to offer or not. How, just with the totality of the circumstances, is that meaningful representation?
Given the totality of the circumstances, Your Honor, whether or not the Aquinos, the 2 witnesses referenced in the DD-5s, had gone to Mexico for an extended period of time, as counsel believed, or not.
But he said he didn't know where he got that information from. He just heard it.
He could not recall specifically who he got that information from. That is correct, Your Honor. Whether or not that was the case, these 2 witnesses had no information regarding the theory of acting in concert, and all of the arguments that my adversary just set forth were presented to the jury, and yet the jury still requested that the court reread the instruction in acting in concert back to them. There was a great deal of evidence, even if the jury believed that Stephen Valle was the trigger man, to support the theory of acting in concert, and the testimony from these 2 witnesses could not speak to that evidence at all. For example, the motive. Even the defendant conceded that Stephen Valle had no motive to shoot these people. The fact that after defendant got the gun from Stephen Valley, he pointed it at these three witnesses. And all three of these witnesses testified that the defendant then said, I told you I was going to get you. I told you I would fuck you up.
But this was after the shooting.
This is after the shooting, yes. That is correct. The two witnesses in the DD5s even mentioned this group of men together that all ran away together. So even if their testimony had supported Stephen Valley as the trigger man, it still could not speak to any of this evidence to support the theory of acting in concert, which the jury was clearly considering.
Could we take the events that occurred before the shooting also as proof that Valle and this defendant, Soriano, were acting in concert?
Absolutely, yes. The assault defendant himself testified that he received the gun from Valle that he then hit the complainants with. That Valle was the one who initially had the gun, that he and Valle and another went looking for these three witnesses after the fight in the bodega. The defendant was aware at that point that he had the gun from Valle. Defendant testified that Valle was imploring him to go to North Carolina with him. All of these factors strongly support that these two were acting in concert, again, whether or not defendant was the trigger man. And that is why the fact that counsel had not spoken to these witnesses did not in any way deny the defendant a fair trial or deprive him of meaningful representation.
Okay.
We ask that this court affirm the conviction. Thank you very much.
You may proceed.
So respondent claims now that it wouldn't have mattered if Vi was the shooter, but the prosecutor at trial had a very, very different approach. The prosecutor admitted prior to trial that he wanted to admit a photograph of Valle because he said it was very important because the defense is going to say these witnesses are lying or mistaken and Stephen Valle did the shooting. He told the court that before trial.
But the defense counsel would have been aware that the defendant was, they were proceeding under an acting in concert theory as well, right?
Yes.
Okay.
And at summation, the prosecutor vehemently argued that Stephen Valle was not the shooter. He said, there's zero evidence in front of you. There's no evidence. It flies in the face of the scientific evidence that Valle was the shooter. This was all improper, but it underscores that it was vital to their case to disprove Mr. Soriano's testimony that Valle was the shooter. Otherwise, he would not have devoted his entire summation virtually to proving this. And to the extent that respondent is relying on Mr. Soriano's own testimony in his defense to make out an acting in concert theory, first of all, he was very clear that he did not assist in the shooting, had no knowledge, had no shared intent. If the jury credited him, which they very well may have if they heard from witnesses corroborating the core of his testimony, they would have had to acquit. But furthermore, he may well not have elected to testify had the defense had access to independent, credible witnesses consistent with the forensic evidence whose testimony would have contradicted the only prosecution eyewitness to the shooting. Under these circumstances, it was inexcusable for his counsel not to reach out to these witnesses and even attempt to interview them or speak to them. So we would ask that the court reverse.
Thank you.
Thank you.
Matter of Gloria.
Good afternoon, Your Honors. Eric Wertheimer, Proskauer Rose, attorneys for the minor child. As the family court repeatedly mentioned in its decision, this is a straightforward case with an ample record to support awarding custody to the aunt. I'd like to focus on part one of the two-part inquiry governing guardianship, and why none of the arguments the mother raises in her reply brief change the family court's holding. As to the first factor, extraordinary circumstances, they clearly exist here. It is black letter law that a prolonged absence from a child's life is one way to establish this factor. As the family court properly noted, it is, quote, undisputed that the child's mother had not had custody of the child for almost 10 years. Courts in New York have found significantly shorter amounts of time to suffice. The record shows that the child's father had sole custody of the child after his 2014 petition was granted. And during those proceedings, it was found that the mother had neglected the child and should only be allowed supervised visits.
So after the father passed, the aunt took custody, the paternal aunt took custody of the child.
That's correct, Your Honor.
And the mother still had no contact with the child, or sporadic?
She had sporadic supervised visits. And it should be noted that during the prior proceedings, the supervised visits were contingent upon her completing an alcohol treatment abuse program, and she had failed to complete that program. The mother argues in her brief that more than just the passage of time is required to establish extraordinary circumstances. But the case law she cites discusses separation of up to a year as being insufficient, not 10 years. And even in those cases, the facts are distinguishable. In Ilana S. v. Richard P., First Department, 2018, the parent was already caring for the child and providing financial support. In Juan J. R. v. Crystal R., First Department, 2016, the parent had no prior history of neglect and was already caring for a sibling. Contrary to those cases here, the family court found that the mother had made no meaningful effort to reunite with the child. I will spare the court the discussion of the second prong and refer to our briefing.
And the child also stated that, did the child state how the child felt about who should be their guardian?
That's correct, Your Honor. The child said that she would like to stay with the aunt, and while it's not dispositive, it should be given great weight given her age.
16, right?
That's correct.
Is any expert testimony required for extraordinary circumstances?
No, Your Honor. There's no case law to say that in this case either. If nothing further, I would ask that this court affirm the family court's decision. Thank you.
Thank you. Thank you very much. People v. Jorge Luis.
Good afternoon, Your Honors. Brian Furst from the Center for Appellate Litigation. I represent Jorge Luis. While still outside of 290 Reservoir Place, the officers aimed their guns at Mr. Luis the second that they saw him.
So let's back up. The waiver, is this a valid waiver?
No, Your Honor. The waiver is invalid. First, the waiver must be viewed through the lens of Mr. Luis at the time of the waiver, who was 21 years old with an 8th grade education. He had never waived his appellate rights before. There's every reason for the court here to be as careful as possible when explaining these rights to Mr. Luis that he was waiving, and the court just wasn't careful at all. For instance,
when you say as careful as possible, is that in case law?
Say that again, Your Honor.
That statement that you just made, that because of his level of education, the court, and that he had no priors, I take it?
He had a YO and a JD.
But he had never waived his right to appeal before?
Yes.
It was incumbent upon the court to be as careful as possible. So the court should have taken precautions with him just to make sure that he, as opposed to anybody else, but he understood well exactly what he was waiving.
Yes, Your Honor, I believe so. And at the very least, to give a very clear colloquy and not one with errors in the court's.
And what were
the
errors?
The question I thought was, where in the case law does it state that?
Well, this court has found numerous appellate waivers invalid on the basis of a person's particular circumstances and their ability to understand. That we've cited to those in our papers. I don't have that.
So is there anything in the record to suggest that because this individual was 21 years of age, that in and of itself would lend one to believe that he was less capable of understanding than someone else?
I think that we could just draw that inference on our own, Your Honor, that a 21-year-old just with an 8th grade education might have a difficult time understanding a highly complex criminal proceeding.
Okay, but in this particular case, the court followed the model colloquy, did it not?
It did not, Your Honor. It did to a certain
did.
point. It did to a certain point, Your Honor, and
It tracked it, advising he could still file a notice of appeal within 30 days, waiver foreclosed, most claims are error. I thought that from what I saw, it tracked it almost pretty much verbatim.
not the critical part as it relates to our claim, Your Honor. What the model colloquy says is that when relevant, when a appellate waiver covers a suppression motion, that the court should include that language. And also, the model colloquy contains claims that survive an appellate waiver. So in terms of describing to a defendant what claims don't survive and what do survive, the model colloquy is far more comprehensive than what the court
The waiver
gave.
foreclosed most claims of error and challenges to whether or not the sentence is imposed, right?
Right, so most claims, but so that communicates to Mr. Luis that some claims survive, and the question is, well, what claims
Okay,
survive?
was there a written waiver?
There's a written waiver that's in
And did the court go over the written waiver in that did the defendant acknowledge that he had read it and signed it after conferring with counsel?
Yes, Your Honor, but the waiver that we have in the record is in Spanish, and it's there's a serious error, translation error with with the waiver.
But isn't there on the record counsel's statement to the court that they had gone over the written waiver with the client, with this defendant, and explained it to him?
Yes, Your Honor, that is in the record, but first of all, the written waiver cannot cure any on-the-record error, right? And more, the written waiver itself contained this critical mistranslation, right? It used the word convicción for the word conviction.
Well, that's a Spanish waiver, but he also had a written waiver in English.
But he needed the Spanish waiver. The Spanish waiver was for him, and we also do not have an English waiver in the record.
Well, we know that there was the official court interpreter was the one who went over the waiver with the defendant.
I believe it was the attorney, or I believe it was the attorney or the interpreter. It's not clear from the record.
I think there would be an interpreter.
Did
There was an
Mr.
interpreter.
Lewis tell probation that he had no problem
Excuse me, Your Honor?
understanding English? That he told probation?
Well, no, that's not. I mean, he does speak some English and he speaks some Spanish. He said that he could communicate in some of those questions, but throughout the proceeding, he needed an interpreter. But that doesn't mean that the record shows that he was knowingly and intelligently signed this waiver.
So why don't we get to the substance of your argument?
Yes, Your Honor. So there's no dispute here that this was a level 3 seizure, right? With without any individualized suspicion. The court below held that, but nevertheless, they upheld the seizure because the officers had a reasonable suspicion that somebody inside the house had a gun, and combined with a officer's safety rationale. But the Court of Appeals, nor the Supreme Court, has ever held that the individualized suspicion requirement is negated if you have reasonable suspicion plus officer safety, right? This is a new exception that the people are arguing for here.
And in fact, when they arrived on the scene, they had responded to a 911 call, but there were certain individuals leaving the establishment that they let go, and they confronted your client.
Yes, Your Honor. They moved straight past 5 women that were exiting the building and zeroed in right on our client and his 2 friends.
Did the 911 call talk about, the 911 said 2 guys, about 5'6" tall and medium build.
Yeah, and Mr. Luis is tall and thin build. He
But
looks
this
nothing like
goes
that.
to the fact that the females those are individuals who appeared to be female, were quote unquote let go.
But to the extent that the police are finding that tip reliable, those 2 people were walking towards Bainbridge away from 290 Reservoir. So if they're crediting that tip, they're in the completely wrong place, Your Honor. So,
You have time on rebuttal.
yes, ma'am. Thank you.
Good afternoon, Your Honors, and may it please the court.
So in terms of the waiver, although it appears that the judge did track the model colloquy, was there certain omissions in terms of, I think your friend mentioned the suppression issue?
Yes, Your Honor. The court's colloquy largely mirrored the model colloquy. However, we recognize that there were minor departures in that the court didn't list examples of claims that survive. Nevertheless, the defendant signed a written waiver in consultation with counsel after reviewing the contents of the form.
The Spanish waiver that mixed up the words for conviction and sentence, how should we look at that in terms of his understanding? Is that relevant?
No, Your Honor. The mere mistranslation of those two words in the form doesn't undermine the defendant's understanding, given the totality of the circumstances, given the court's model colloquy, the detailed written waiver defendant signed, and defendant's affirmation under oath that he reviewed the waiver with. That counsel discussed the waiver with him, and that he reviewed the waiver himself before signing it. On this record, the only conclusion supported is that the waiver is valid. Turning now to the suppression issue, Your Honor, the police acted lawfully and exercised reasonable prudence in a fast-developing situation fraught with danger when they entered a dark basement with their guns drawn and ordered defendant and his two cohorts to stop moving. Of course, the 911 calls, I should say, there were approximately 8 or 9 of them, provided conflicting information about the location of the shooting and a description of the suspects. However, that ambiguity was cured as soon as the officers arrived on scene and spoke with the 3 or 4 civilians who flagged them down and pointed out the house to them. Beyond that, the officer was able to look inside, see people acting frantically, running up and down the stairs. And at the same time as he's making these observations, there's a radio report about a possible escape through the back door. About a man running down Perry Avenue, which the officer interpreted as a person potentially having escaped through the back door. So under these circumstances, the officers were justified in acting to ensure their safety by keeping their guns. By entering the house with their guns drawn. My friend makes the point that the officer should have stopped to question the women who had stepped out of the basement first. Again, I think that ignores the danger fraught in the circumstances that these officers were facing. It was nighttime. They're entering a house where shots were reported fired. The basement is dark. It's totally understandable that Officer Roach and his partner, Officer Roach and Officer Gomez, prioritized their safety as the paramount consideration before speaking with the other women. And more fundamentally, the officer testified that there were at least 6 other units on scene. So it's certainly conceivable that other officers that Roach understood, other officers would arrive and question the women while he dealt with the men inside and address that immediate threat. Unless the court has any further questions, we would just ask for an affirmance. Thank you.
Thank you.
So first of all, Your Honors, the respondent just said a person escaped out the backyard justified the cops running into the house with their guns drawn. If the officers are pursuing an escaped person, the house is the last person that they should be looking for that person. So I don't follow that argument. But the most important point that the DA did not respond to is that there was no individualized suspicion here. That's the question, is why is there no individualized suspicion requirement here, right? The people's rule that they're suggesting here and the court's rule below is that if the officers have reasonable suspicion that someone in a location, some person in a location has a weapon that was used, that the police can seize anybody in that location at gunpoint without any individualized suspicion, right? There's no reason that wouldn't apply to a park.
Well, wasn't it a little bit more than that? Because the 911 calls were shots fired. And when the officers arrived on the scene, again, when they spoke to individuals, it was shots fired. So isn't that a little bit more than, there's a man with a gun or a woman with a gun in that apartment?
I agreed, Your Honor. The rule that I was announcing to the court, I think, would apply. That's what I'm trying to say, is that it's response to shots fired. The reasonable suspicion that somebody has used a gun or is about to use a gun and then that gives the police authority to detain every single person in that area at gunpoint. And there's just no case law to support that, right? The bright line rule that exists is that a level 3 seizure on the basis of reasonable suspicion always requires individualized suspicion, right? There's exceptions to these bright line rules, but we just don't have that exception. So what the people are essentially arguing for is an expansion of this court's ruling in Henderson when you said that the officers were justified in detaining people while they were executing a search warrant. But there, of course, you have a judicially signed search warrant, a probable cause to go into this place. We're not talking about reasonable suspicion. So, of course, there are instances in which police safety would justify not adhering to the individualized suspicion requirement, but it's just not here. It's not merely a showing.
Wouldn't indigent circumstances apply here?
Not here because there was no finding of probable cause, Your Honor. So an actual finding of exigent circumstances would require probable cause and exigent circumstances. And what the court here found is that it was justified on the basis of reasonable suspicion.
What about the indigency created by the 911 calls?
So again, Your Honor, there are exigent circumstances going on here. Yeah, there's gunshots, there's shots fired, but to enter a home on an exigent circumstance basis, we need to have probable cause.
So it's a fluid situation. You have all these 911 calls about shots fired. You have individuals at the scene stating that there were shots fired and pointing to the location. What were the police supposed to do at that time? They were supposed to go and get a search warrant?
So first of all, Your Honor, no person on the scene said shots fired. The people on the scene said it's that house there, it's always that house. So they didn't say shots fired in the house. I saw someone shoot a gun. They just said it's always that house, which is inherently suggests that there's some history there that they might be basing that upon.
What about the 911 calls?
There were shots fired reports. I'm not saying that there weren't.
So that's my question. So your argument is that at that point in time when they respond to the scene, they should have gotten a search warrant for the location?
No, Your Honor, they should have gotten probable cause before they went storming in with their guns.
And what would the probable cause be? You've spoken to the individuals at the scene who point to the location, and you have the 911 calls. So what should they have done at that point?
They should have asked further questions of those people that gave them those tips.
In the middle of a shots fired exigent circumstances situation, they should have done what?
They should have asked an additional question of the people standing on the street.
Like what? Other than that they pointed to the house and they point to the house. What else? What other questions should they have asked? Again, when you have these 911 calls about shots being fired.
They should have said, "Did you see that? Are you basing that on? Did you see that? Did you see the shots fired? What did they look like?" Because if they're basing this on reason, right here, the court found reason.
Okay, and they say no.
If they found no, then they don't go in the house.
They don't go in the house. They don't go in the house where there are multiple 911 calls about shots being fired. They do not go into the house. What do they do?
If they had no basis to assume that those shots, that the person who ran into that house, if the person didn't see that, then there's just not even reasonable suspicion that there's anyone in the house with a gun. So they need a factual basis to go into the house, right? They need probable cause to go into the house and hold up everybody at gunpoint. To do that on reasonable suspicion alone, because that's what the court below found.
I don't know. Did the cases actually state that? I was actually not kind of focused on that portion of your argument, but the cases actually say you need probable cause in order to enter the location. Reasonable suspicion is insufficient.
Reasonable suspicion, yeah, that's Payton, Your Honor. That's U.S. That's Supreme Court Fourth Amendment case law.
It's a warrantless search of the premises.
Right. So this is it's exigent circumstances. When is it justified?
We're not talking about a warrantless search. We're talking about exigent circumstances where you don't need a warrant. I don't see that you need probable cause. But you know what? I will take a look at your. Obviously, we'll take a look at your arguments again. Thank you.
Okay, Your Honor. And the last thing that I would just point out is that the court below based their decision on reasonable suspicion. So to the extent that it's not really before this court now whether or not there was probable cause that could have justified a search. Thank you, Your Honors.
Okay, thank you. People v. Chad Hooks. Yes, you may proceed.
Good afternoon, and may it please the court. Jacqueline Shelton, and I represent Mr. Hooks. There was no probable cause.
What do we do about the doula case, and then which cites Jones? What do we do about that with these license plate covers?
I anticipated the question, but What that case did not address, and what is before this court now, is the finding of probable cause was not addressed on the people's appeal, nor the credibility of the officers. What was it? It was the people's appeal, so this court did hold that there were some issues that were not properly before the court based on LaFontaine. And so what we are narrowing our argument to is the probable cause and the credibility, because it was not able to be addressed on the people's appeal.
The probable cause as to what? So we have the license plate covers, and we therefore have a violation of the vehicle and traffic law. So is that not that's a basis to stop? You agree?
I disagree, because the original on the people's appeal did not reach that issue. It was because it was not decided adversely to the people, and it was their appeal.
Okay, but let's accept that.
Yes.
We still have this VTL statute that says you can't cover your license plate. We have a couple of cases. Let's leave Dula out of it, and let's talk about People v. Jones that came out of the 3rd Department, on which they, it was cited. What do we do about that? If you can't cover your license plate, and that's what the officers testified to, that it was covered in a certain area, so it obstruct the Garden State.
I mean, it's an issue that I do think, as a society as a whole, raises concern when we're in the context of a pretextual stop for something that, if we are looking around,
but that's the whole point. If in fact you follow these, if we accept these cases, then it's not a pretextual stop. If you follow the cases, then the basis for the stop is as articulated by the officers, which is the covered license plates.
Well, pretext, it was conceded to be a pretextual stop. These officers were anti-crime officers that were seeking evidence of something else, and that has never been contested by the people, neither on their appeal or in the hearing court below.
Well, I mean, when the officers testified, unless I missed it, they didn't say, yes, this was a pretextual stop. They didn't say that. They said that they saw somebody speeding or moving fastly amongst other cars. One said they saw it from 5 blocks away. I mean, okay, but the VTL statute that they're relying on is the covered license plate. And I just want to know, what do we do about it when that exists?
So the issue here is about timing, because the officers, even if you accept that that is the basis of their stop, they have to observe that before they initiate the stop. So what they say primarily the basis was they first saw speeding, and that was rejected by the court below. And so building block on top of that, they were intending to rely upon the pretext of speeding, and then next you have the plate that comes after. So if that initial basis is rejected, so too falls the second basis. Your Honor touched upon one of the key points of credibility here, because our argument that I'm focusing on today for this, for argument, is about credibility. 5 blocks away. 5 city blocks away is a quarter of a mile. This court is allowed to...
Well, counsel, forgive me for interrupting you, but in the transcript, on cross-examination, Officer Rupert, I think he was the driving officer, he was driving the vehicle, he was asked how far away was he from the defendant's vehicle when he noticed the plate. And he said that he was 1 to 2 car lengths away, not 5 blocks away. And that is when he initially noticed that the plate was obstructed. So he says that was initially, he saw the vehicle to his left, 1 to 2 car lengths away, noticed the plate obstructed. That drew his attention, and then he saw them speeding.
Right, and the 5 to 7 blocks was, he followed the vehicle for 5 to 7 blocks before he activated the turret lights, the emergency lights.
So Officer Nugent is the one who talks about spotting it from 5 blocks away. Rupert does say that he sees it a few car lengths away, but that he initiates the vehicle lights, and they were on for about 2 blocks or so while he was pursuing the vehicle. But there are, this is...
But the question is, once he spots the plates, obscure plates, in violation of the VTL, right there and then, does he have a right to stop them because of a VTL violation?
Well, in our point 2, we contest that this, as factually applied, was actually a violation of the VTL. But I think the issue here is of credibility of multiple different stories. And so...
But the court below found him to be credible.
And see, that was going to be my other question. Don't we give deference to the motion to the motion court?
The court below noticed that there were
Suppression
issues
court,
here.
yes.
Yes, the court below noticed that there were issues, found a lack of credibility as to speeding. What
Right.
we are saying is that the court below did not go far enough because those credibility issues extended to the plate observation as well.
But the fact that the court accepted some credibility and rejected some credibility, doesn't that actually work against you in this instance, in that they were really paying close attention to credibility and they found certain portions incredible and credited others?
The court considered but did not give proper weight to some of the major inconsistencies here. For example, in the court's order, if you consider the testimony of Lieutenant Holschick, which he says he couldn't even, the plate wasn't even visible from the street. The court relegates that.
He was sitting in the back.
He was in the back seat, though.
Yes, but he very clearly testified that he was able to see speeding. So it does defy credibility that he's saying
the plate is smaller than a vehicle that is speeding in front of you, whereas the plate, you may not be able to see from the back seat whether or not part of it is obscured.
I think when you look at what his testimony says, he's almost exaggerating the covering of the plate. He starts to say that he couldn't even see what state the license plate was from, and that just simply is not possible.
Is it a credibility issue when you have a license plate that something is covered? Is that subjective or objective? Some part of it was covered, albeit small, but it is objective that that was the case. So I don't know all this credibility analysis is as warranted as giving it.
The prosecution still has to prove with credible evidence that they observed this violation prior to a seizure of the vehicle. So that's where credibility comes into play. Point 2 addresses, if we interpret it this broadly, it would lead to absurd results. That this cannot possibly be, given the fact that any minuscule covering could be used as a pretextual basis, that simply is not something that society would accept.
You keep saying pretextual, and I don't know that, way back in the day, anytime an arrest was made or stop was made by anti-crime, it was pretextual because we knew from a lot of cases that that's what they were doing. They were just stopping vehicles on the roadway. So we knew that. But I don't know that you can necessarily say that every stop is pretextual. And I think my colleague's point is well taken. The obscured plate, is it objective or is it subjective? I guess your argument is that they decided that they were going to stop this vehicle regardless. And when the speeding, they came out with speeding, and then they came out with the covered license plate. And that may, in fact, be what occurred. But in terms of the record, and in terms of the testimony, I don't know that it bears it out. But you have time on rebuttal.
Good afternoon, Your Honors, and maybe evening now. May it please the court.
Not quite, but if you don't hurry up, then it will be.
Yeah, well.
I have a question.
Your Honor. Yes, Your Honor.
My question is, did the court below need to find all the officers credible on one issue? Or could it have found, for instance, Officer Rupert, who said that he was 1 to 2 car lengths behind the defendant's vehicle when he spotted the obscure license plate, find him credible on that issue, and on that alone have found, well, they had a reason to stop?
Sure, absolutely. A fact finder's job is to assess the credibility of the witnesses and can make mixed credibility findings.
But if all the witnesses, these officers all testified about something different, right? They all saw different things at different times, this speeding from different distances. At some point, you have to call it like it is, right? And say maybe there is no credibility here.
I think for the speeding, that's exactly what the judge below did. They looked at the speeding testimony and they found there were too many inconsistencies to really credit that part of the testimony. But on the license plate part, that was fairly consistent. They all agreed that they saw the obstructed license plate. The post-arrest photo of the license plate corroborated that it was obstructed.
Let me just ask this question. This
Sure,
is
Your
something
Honor.
that's bothering me. The license plate covering is from a dealership?
That's right. In Schenectady, I think, is what the picture
I mean,
is.
I don't even know how to say this.
See, if a dealership issues the license plate cover, then why is it in per se okay? Why is it a violation if the dealership does it?
Right. That's my question.
If the dealership issues the license plate?
Yeah.
It's not as if it was a vanity plate. It was a
vanity.
vanity covering.
Well, the dealer may have issued the license plate, but the driver or whoever, was ultimately responsible for taking and putting it on. The car.
The dealers, I don't know when the
They
last
put
time
it
you bought a
on.
car, but when you purchase a car, especially you purchase a new car, you lease a car, they change your plates. Unless, you're now changing your plates for registration if you get a new car.
Well, I'm not, Your Honor, I'm not really sure of the deal. It's been a while since I bought a car. But
Well, yeah, trust me. The dealership is the one that puts the plates on the vehicle, especially if it's a new car.
I think
And they're the ones who put the plates on.
I think what you meant it would be the driver's, the owner's responsibility to remove it or to adjust it in such a way so it didn't obscure the.
Right.
Yeah.
And I think what the ultimate issue is in this case is, officers are driving down the road and they see a license plate violation that gives them probable cause to stop the vehicle.
Is that what happened here, based on the credited testimony? Was it they perceived a speeding infraction first, which ultimately the suppression court found was not credible, or did one of the officers ascertain there was a problem with the bracket for the license plate first?
I'm not sure there was necessarily an order to it. I think some of them initially they said the speeding and then they saw the license plate. I think some of them don't specify which they saw first. I think what is clear is that they all testified that they saw the license plate violation. There was a brief conversation, and then Officer Rupert turns on the emergency lights, and that's when they pull the car over.
Would it be a problem if it was the speeding first? Because then would it be justified at the inception if it turned out that the initial reason, the initial infraction they thought they perceived was found to be not credible?
I don't think it would matter the order, but I did want to point out one thing is that the suppression court below never found that the officers had lied or the car had not been speeding. That was not the holding at all. What they said was that there was too many inconsistencies and problems with the paperwork that really they felt that the people did not meet their burden of proving that the speeding had occurred.
But if the speeding was let's accept that that's the reason why they started following this vehicle, and that's not accepted by the court, what happens to the rest of the evidence going forward?
If the speeding isn't accepted by the court, well, there was the second license plate justification for the stop. I think as long as at some point before the stop, the officers see the obstructed license plate, that gives them probable cause to stop, even putting aside whatever happened with the speed.
Well, the officer testified that he saw the vehicle speeding and he saw the obstructed license plate simultaneously.
That's right.
That's what he said.
Or simultaneously or in quick succession. It's often not altogether clear.
Not attenuated. Right?
Not attenuated.
all at the
Yeah,
same
right. I
time.
don't think that plays into it.
Well, he was asked specifically, simultaneously, and he answered yes.
Yes.
That's what he answered.
I think I don't think the two are as closely linked though, because they're two different perceptual things going on. One is trying to assess the speed of a car as it's going down relative to your own speed when it's ahead of you. The other one is the simple perception of seeing the license plate and seeing whether or not it has a frame over it, and whether it's partially obstructed. And I think that's a much simpler observation and one that all the officers testified to unanimously.
Probably more objective than trying to gauge the speed.
Sure, absolutely.
But I'm sure officers would testify that they were trained, and based upon their training and experience, they could tell the speed of another vehicle on the roadway.
I don't recall about
No,
it.
not in this record, but I'm sure that's what the police say when they pull you over for speeding, or we've had other cases where there's a stop.
Your Honor, I know I didn't really talk about the VTL statute, the statute issue. Is there any questions on that particular point? Okay. Thank you, Your Honors.
Just to end briefly, I do want to note that obviously these sorts of pretextual stops give officers incredible latitude.
Pretextual stops.
I do want
You
to
just love that.
address the court's attention in that in the case law, pretext means generally, okay, we can find a basis theoretically for it, but that's not why we really want to get in the car. And so that's why I'm using the
I
phrase
understand
pretext.
it, but the
Yes.
point was made by my colleagues in terms of it was almost at the same point in time where they observed the vehicle speeding and they see the covered license plate.
So this is where the inconsistency comes to play. Our Officer Rupert did testify simultaneously. On cross, he said speeding first, then plate. The other two, one didn't even say plate until the car was already pulled over, and then the second said speeding first, then plate. So it is inconsistent amongst the officers as to when this observation occurred, but the majority of them say speeding was the basis of the initial attention being drawn and the initiation of the stop.
And is it legally material if the first ground, shall we say, for the stop proves to not persuade the suppression court, but then they have a second ground that does persuade the suppression court? Does it matter that they weren't justified at the inception, so to speak, that their first ground wasn't supported by the findings of the suppression court, but the second one was?
Under the facts of the case, it is material in that it calls into challenge the credibility of the observations and the timing overall. I'm not calling or saying that there's a bright line rule that that's the case, but I do believe in a situation where you have officers saying we saw speeding, at some point we initiated the lights, we intended to stop, and then later, at least two of the officers, not Officer Rupert, but at least two of the officers say later we see the plate. You know, this incredible latitude requires that there be judicial guardrails over these types of stops because it has such a potential for disparate impact on people, and that is laid out in the papers. So this sort of testimony should be carefully considered, and if it defies common sense and logic, like the 5 blocks observation, for example, it should be discredited. And I would ask this court to reverse the conviction and dismiss the indictment.
Thank you. Thank you very much. Thank you both. Freedom Care v. New York State Department of Health.
Good afternoon, Your Honors. May it please the court, Akiva Shapiro of Gibson, Dunn, and Crutcher for petitioner appellant. My client has presented voluminous evidence of the Department of Health's pre-selection of a public contract winner, that party's conflicts of interests, and Department of Health's failure to follow the governing statute and the rules set out in its own request for proposals and definitive guidance given to bidders.
One of the things that you rely on is that, I think it was April of the bidding year, that there was some rumors, I mean, I don't know how else to put it, that PPL was going to be the selected SFI. And other than we heard it from someone, and someone heard it from someone and then published it in a certain forum, what else do you have that's a little less speculative?
So the most direct and definitive evidence that we have of the pre-selection is the affidavit, sworn affidavit from Carlos Martinez, who testified under oath that during a meeting with the state's chief disability officer on April 9th, 2024, This is months before the RFP was issued. A staff member informed participants that, quote, the state intends to choose Public Partnerships LLC to take over as the statewide.
A DOH staff member? Was that?
A chief disability officer, which is connected with the state's disability officer, chief disability officer, speaking on behalf of the state, which of course the disability office was working with DOH.
So did that officer have any direct impact or involvement in the selection process?
We don't know. And the question of the issue, of course, is that in any bid rigging case, the participants in that bid rigging are going to be very protective of that information and do everything they can to keep it from the bidders who weren't selected. We think we've come forward through our own gumption with pretty significant heavy evidence in a situation like this. Admittedly, we don't have the smoking gun where someone from DOH is a whistleblower and has said we selected PPL ahead of time. But we've got a lot here. We asked at least for discovery below, because we think we at least meet the threshold there where we should be able to take limited discovery of the communications between DOH and PPL.
So there was an evaluation that was conducted, is that correct?
There was an
And
evaluation.
The evaluation, from my understanding, there was a technical score, a score that was given to PPL, right?
Yep.
Okay. So how then would that evaluation have been rigged? Okay. How would that evaluation have been rigged in terms of the score that was given to PPI?
Sure. So two answers if I could give on that. One is, there was a question, I think from Justice Pitt Burke, about the direct evidence. The most direct evidence that we can point to that is uncontested in the record is that the RFP, first the statute, then the RFP, then the definitive guidance given to the bidders made absolutely clear that subcontractors would be invalid, disqualified, if they either were not doing business before 2012, or they had an association with a licensed home care services agency. PPL put in a network of 31 subcontractors, 27 of which were disqualified under that statute, and nevertheless, they were repeatedly awarded points throughout the bidding process for their subcontractor network. And the case law is very clear, and that, your honors don't have to reach the question of was there a pre-selection here, although we think we have enough evidence to get there considering the stakes of the integrity of a public bidding process. But at the very least, you can find that they changed the rules, they deviated from their own rules. The case law, the Court of Appeals has repeatedly overturned bid awards where an agency has put out certain rules and then has deviated from that rules. And it's uncontested that that's what happened here.
The rules, where you're talking about the subcontractors, there was a requirement that we comply with a statutory minimum, but there wasn't a penalty for additional, right?
Anyone was allowed to include subcontractors, and this is a red herring or a mischaracterization that respondents make. We're not saying that the issue was that DOH looked at subcontractors. That was permitted. The issue was that they looked at them and then they awarded points to PPL for disqualified subcontractors. And that was improper under the statute and under the RFP and under the definitive guidance. And on top of that, the conflicts of interest issue or evidence here also is uncontested. It is uncontested that 26% of PPL is owned by Public Consulting Group, that company has hundreds of millions of dollars of active contracts right now with DOH, including advising in the Medicaid program on the CDPAP program, and that fully over 10% of DOH's Medicaid employees, this is in the Medicaid director's sworn affidavit, Mr. Basiri, fully 10% of the Medicaid employees of the Department of Health are actually employed by an affiliate of PPL. That is uncontested. And to me, it is.
So wait, so is one, assuming that is true, is that a violation?
It is a conflict of interest, and the RFP requires that there be no bid awarded to a conflicted party. It also says even a perceived conflict. And I don't understand how any objective person hearing that information cannot at least say that there's a perception, a problem of a conflict of interest, given those facts, given that 10%
So the question is, does that perception require that they not get the bid, that they not be awarded the bid?
Yes, Your Honor.
Is there something in the regs which would state that?
Absolutely. The RFP explicitly and specifically states that that the bidder must ensure the avoidance of, quote, actual or perceived conflicts of interest. That's at section 4.5D of the RFP. And the case law is also clear that a public contracting award, is arbitrary and capricious if it violates the purposes of the public contracting statute, which is prevention of favoritism, improvidence, fraud, and corruption. It's very clear.
You do have time on rebuttal. Yes, you do.
Thank you, Your Honor.
Thank you, Your Honor. Andrea Trento from the Office of the Attorney General. May it please the court.
So I had asked a question concerning the evaluation. I saw, so apparently on the evaluation, PPL received a mixture of good, bad, fair scores, et cetera. So how could this be quote unquote rigged?
Your Honor, that's an excellent point. The evaluation actually, just to take my friend's characterization, of the evaluations, he said they were littered, I don't remember the exact verb, but they were littered with all these references to the subcontractors that were cited by PPL. There were 39 different categories that each of the three evaluators rated the bidders on their technical submission. So 39 times 3, I think, is 117. So there were 117 possible 0 to 5 scores that could have been given to the bidders. 7 of those categories, 7 of those individual scores included references by one of the evaluators to PPL subcontractors. I would submit, Your Honors, and the raw score, I think, was 410 or 418 for PPL to something like 360 for Freedom Care. If you were to take the scores awarded on each of those 7 items and move them to 0, let's grant that. They shouldn't have done that. They should have gotten 0 on those scores, which is not supported, but let's say we just do that for this exercise. And Freedom Care also complains about the fact that they were allegedly penalized for not including subcontractors. That's not what happened. We have an explanation for that we refer to in our brief, but let's accept that. Let's accept it for the purpose of this exercise. There were 5 individual reviews that referenced the absence of subcontractors, 5 out of the 117 that referenced the absence of subcontractors and presumably penalized or allegedly penalized Freedom Care for that absence. If you award Freedom Care 5, the highest score on each of those categories, to correct this error, guess what? You'd still have PPL winning that technical submission by over 30 raw points. I think that recalculating it, and Your Honors can do it, it's 1252 to 1253 of the record, and I have individual page sites of the record that I can provide to show where in the voluminous evaluation materials these subcontractor references took place. PPL still wins that technical score by 30 points, and this doesn't even get to the fact that PPL's cost submission was 45% better than Freedom Care's. And so the standard here for review is rational basis. Freedom Care has thrown a lot against the wall. Individually, each of these things doesn't really stick, but they're trying to create this issue by pointing to numerous issues, several vague statements.
What about the 26% of, talk about 20, the conflict?
Yes, Your Honor, there are two responses, or more responses, but I'll focus on 2. First, there's no disclosure standard in the RFP or reference in the materials that are referenced in the RFP that would require disclosure of this interest. It's not an interest where 26% of PCG plus its executives own PPL. They own 26% of a parent who owns a parent of PPL.
But would that constitute a conflict?
Not under the vendor responsibility questionnaire. PPL was not required to disclose that under the VRQ. Now, moreover, VRQ only required disclosure of the direct owners, not this sort of conglomerate of one entity plus 3 of its executives. There is something else in the VRQ that does require consideration, and that's something referred to as affiliated entities. But the threshold for ownership for affiliated entities in the VRQ is 50%. So even under the collection of executives and PCG who own the parent of the parent of the parent of PPL, they're not affiliated entities for the purpose of the VRQ, never required disclosure. Second point I'll respond to on that issue is there's no plausible allegation that this contract that PCG has poses any sort of conflict with regard to PPL's ability to perform on the contract. And if your honors look to section 4.5 of the RFP, that is the
I don't know so much about if it's their ability to perform under the contract, it's the great interest that New Yorkers have in the integrity of the process. And so is there a perceived conflict in the awarding of the contract?
Understood, Your Honor. And my friend makes a lot of reference to the fact that 10% of the employees or 10% of the individuals working at DOH were actually affiliated or employees of this subsidiary of PCG that have a staffing, consultancy relationship with DOH. But what is unrebutted is that none of those individuals had any role in the RFP process. We know who the evaluators were. They're in the administrative record that's been produced. They all signed attestations that they did not have conflicts that would prevent them from doing this. The fact that their PPL has a distant relative that has a contract with DOH is not disqualifying. PPL itself has another contract with DOH. We haven't heard anything about, oh, that poses a conflict, because nothing about having more than one contract with an agency gives rise to a conflict. I see my time is up and happy to answer further questions, but I'll rest.
Good afternoon. My name is Jonathan McCardle. I represent Respondent Public Partnerships, the successful bidder in the Department of Health's CDPAP procurement and the respondent in this proceeding. I'd like to begin by picking up on the conflict of interest issue that the Attorney General's office just commented on. Our position is there were no conflicts of interest. PPL is the largest and most experienced fiscal intermediary in the country. We have over 50 different contracts with over 20 different states. We are a freestanding, independent company that has its own board of directors, its own management team, and it has a minority owner that has no ownership or control of 16%, not 26%, and I think that's a key distinction that the appellant has not raised to the court. The 26% interest is the appellant's attempt to combine the public consulting group's 16% with 3 individuals who have a 3% interest each. So they're lumping all of those interests together to get to a 26% threshold, but that's just not how the math works. That is oversimplistic view of things. Another key point I'd like to make to this court is that a panel of judges from this very court has already denied a preliminary injunction in this case. That preliminary injunction took a 3-part view and took into account the likelihood of success on the merits. Was denied on June 11th. That's in the docket at record number 11. I'd also like to emphasize that PPL offered the best value to the state of New York. This is a CDPAP program that the state was hoping to achieve $500 million in savings in. The RFP was weighted 65% technical score and 35% cost score. The cost score alone, PPL was $800 million less expensive than Freedom Care. Our per member per month rate was $68. Their bid was $126. Turning to the technical proposal that made up 2/3 of the bid, we had a superior network of subcontractors. We complied with all the procurement opportunities and responsibilities that were set forth, and we had the best and highest rated technology in the marketplace.
That may be the case, but again, the issue is the integrity of the process and whether there was some predetermination that PPL would be the winning bid.
Yep, and there I would turn the court's attention to the Medicaid director, Amir Basiri's supplemental affirmation. At record page 2,975, he swore that no DOH employee affiliated with PCG Staffing Company was involved with the CDPAP procurement whatsoever. That is the end of the story. There was no conflict of interest at that whatsoever. DOH Medicaid spend is over $100 billion annually. The Medicaid director's sworn testimony at 2,977 showed that PCG had a 0.025% interest of the contracts that Medicaid currently has in place. That's less than 1%.
Thank you.
I would ask this for the lower court's decision to be upheld. Thank you, Your Honor.
Thank you, Your Honors. On the scoring question, as Your Honors can see, all of the factors were open-ended, good, fair, excellent, and they were all subjective factors, the 37 factors. So it was not hard to have manufactured the result that they wanted.
Was there any objection to that, the way that those things were, the questions were formulated, or that standard prior to the bidding process commencing?
Yes, absolutely. Many of the bidders asked for further clarification on the scoring, including specifically what factors were going to be used.
Was
and
that
DOH
objections or asking for clarification?
Those were formal questions, and DOH gave formal answers in which over 200 times it said it was not going to provide further information on the scoring matrix, on the evaluation factors, on any of those things. And
In your experience,
issue-
oh, go ahead.
No, I was just going to say, what about the issue of the cost? That yours was so significantly higher in cost?
Sure. So I think the cleanest answer is that the Court of Appeals said explicitly addressing this question and overturning and finding arbitrary and capricious an award in that where the bidder got the highest score because it deviated from criteria specified in the RFP. That's the Acme Bus Corp against Orange County. And in Acme Bus Corp against Board of Ed, the Court of Appeals said, quote, favoritism or irregularity in the bidding process may ostensibly produce monetary savings. However, the use of such means to meet that singular end is still unsustainable because the complete public interest is ultimately promoted by fostering honest competition. They cannot get out of bid rigging, out of conflicts of interest, out of deviations from the standards in the RFP and the statute just because they say it's going to be cheaper. That is not how our public contracting system works, and if it did, it would not be a fair process. On the 16 versus the 26%, they concede that PPL owns 16% of PCG. They concede that 3 of its executives own another 9.9%. How they can say that there's no conflict of interest and you don't add those interests together when you have a complete alignment of interest from a company and its executives to win this bid, that is not how the law worked in any other setting. We have something called structuring. You can't create a transaction that splits up the different parties that all have a similar interest to get to the same end, and that is what they're proposing is valid here in a multi-billion-dollar public contracting setting. The 50% thing is a new argument. I'm pretty sure that wasn't in the briefs. In the briefs, they concede that 25% is the threshold. 25% is the definition of principal owner in that voter responsibility questionnaire they cite. Of course, that VRQ isn't in the record. It wasn't in the record before the trial court. It wasn't an issue they raised before. The issue and that's a disclosure requirement only. The issue is there a conflict or a perceived conflict? If you have a 26% ownership stake from a company that has hundreds of millions of dollars of contracts with the agency, including advising on that very issue, on that very program, and that has 10% of its own employees employed by that program, that at least raises the perception of a conflict of interest. It doesn't matter that the Medicaid director, who, by the way, was also one of the 3 evaluators.
Thank you very much. Thank you all.
May I add just one more?
Oh, I'm sorry, go ahead.
A conflict or a perceived conflict as defined in the RFP.
The RFP simply says conflict or perceived conflict. It says that is not permitted, and that's a bidder cannot have a conflict or a perceived conflict. It doesn't further define that, but in our view, the court has to use its common sense and look from objective matter if this would be at least a perceived conflict of interest, and it would. Thank you, Your Honors.
Thank you.
Thank you.
Alibaba Hotel v. Pros.
Good afternoon, Your Honors. May it please the court. I'm Alex Pros, pro se. Basically, there's 2 legal issues I want to address here. In 2019, I signed a surrender agreement for a rent-stabilized apartment on West 50th Street. It's in the record at page 940. What I want to draw your attention is paragraph 3. Paragraph 3 says, occupant, me, warrants that I won't occupy another unit affiliated with owner. Owner is defined in the first or second paragraph of that document as Alibaba Hotel Corp. Okay?
Wait, well, it says affiliated with the owner. It doesn't say owner as listed. It says affiliated with the owner. Like, how is affiliated an ambiguous statement? Affiliated means affiliated.
I
It doesn't
completely
have to
agree
be
with you.
listed there.
I completely agree with you. The units affiliated with Alibaba Hotel Corp. are solely comprised of the units at 224, 226 West 50th Street. I don't know how there's any question about that. However, we've been in litigation for about 3 years, and now we're in front of this esteemed court on this very issue. But even if this court was to find that the units at the East Side Inn LLC, a distinct legal entity, are affiliated with the Alibaba Hotel Corp., that brings me to my second legal issue. It doesn't preclude the legal rights of due process for an eviction, which the lower court bent over backwards to grant the landlord and Belkin Verdon law firm. They held it under the guise of contempt, which the appellate division has found the remedy for contempt of court is money damages, and then they may, seek application for a summary proceeding. But there was no summary proceeding about the eviction. So I was just thrown into the street by the court sending an erroneous rent using no known formulated method of calculating rent, either under the administrative code or under Regina Metro Parks. So that's why we're here today. What I want this court to do is overturn the money judgment because I didn't breach the contract. I never went back to 50th Street. And I should be restored to possession on 24th Street or given damages for that.
So your reading of this agreement was unit affiliated with owner meant only that particular location?
Correct.
And no other location, only that location?
I don't see how I could possibly interpret this contract in any other way.
So why would they enter into an agreement with you, barring you from that one location, where it says affiliated with owner? Why wouldn't it simply say whatever that location was? Was that the Marcel Hotel?
No, this was Alibaba Hotel Corp.
Oh, this is Alibaba. Why wouldn't it simply say Alibaba Hotel?
I'm sorry, could you repeat the question?
Why would it, if it was only for that location, why would it not simply say Alibaba Hotel as opposed to unit affiliated with owner?
Well, it does only say Alibaba Hotel Corp. The 2-page long contract says the units affiliated with owner. Owner is defined as Alibaba Hotel Corp. The address is listed as 224, 226 West 50th Street. It's not 201 East 24th Street. It's not East Side Inn. It's just that one apartment. And the reason that that is important is because of paragraph 8 of that contract, they also say that I waive rights to bring a harassment claim. I was harassed, but, I guess parole evidence, whatever, they got that claim out. That's what the money was for, okay? They recaptured their apartment. I agreed to never come back. I waived my rights of harassment claims. Everybody walks away, have a nice day.
Does that mean that you cannot rent an apartment or a room at another entity that is affiliated with Alibaba?
If Alibaba Hotel Corp. owned another entity, and Councilor Lafredo brought this up at some point, if they own another entity, I would interpret that to mean that I would not be allowed into that building, okay? Let's say they own, 226 West 80th Street.
Yes.
Can't go there, okay? Anything under the umbrella of Alibaba Hotel Corp., I'm precluded from entering. East Side Inn may be under some parent umbrella of a different corporation. As this litigation's progressed, they've tried to make that point.
But
doesn't matter.
But the way that you're describing it as owned by some other parent company, is that affiliated or not affiliated? Because I think that the issue here is who is affiliated with Alibaba and what does that mean? For me, it's not ambiguous. It means anyone affiliated with it, and that's that's what it is.
So, yeah, sorry.
So can you respond
answer,
to?
I'm sorry.
Yeah, I was thinking about that, and I guess the way I would look at it is like, if Shake Shack told you that they would never sell you another cheeseburger, does that stop you from buying a cheeseburger from Gramercy Tavern?
If it's affiliated with the Shake Shack, then yes, I would imagine so.
But you warranted. Part of the agreement is you got $100,000. You got $100,000, and you warranted that you would not occupy another unit affiliated. But then you did.
I disagree.
How do you disagree? You did occupy another unit. You say, I didn't know. But is there any condition that you have to know You got $100,000 and you were obligated to comply with your end of the bargain, and you didn't.
I've never requested a lease at 226 West 50th Street after I surrendered that apartment. East Side Inn LLC, a distinct legal entity, was not party to that contract, okay? So if I was gonna waive all of my rent stabilization rights, it would have been a very different deal. They wanted to capture that one room, they wanted the harassment thing. They got that. I never went back there.
But the actual words are, you will not occupy another unit affiliated with the owner.
Correct, and the owner is defined as Alibaba Hotel Corp, and the units...
An affiliate.
Excuse me?
Affiliates.
That was my question initially. That's what I'm saying. If it was only Alibaba, then it would say unit affiliated with Alibaba as opposed to saying unit affiliated with owner.
Or it would simply say on these premises.
Right.
Well, I mean, you guys have it in front of you, 940, 941. It says owner. It defines owner as Alibaba Hotel Corp, right?
Right, but owner is not the ambiguous term here. Affiliated or is not the term that you're contesting, right? You're not contesting, you're contesting affiliated. That's the issue. And is it ambiguous or is it not?
It's not ambiguous. Affiliated entities, very different concept than affiliated units, right?
Unit affiliated with owner.
Correct. Not entity affiliated with owner, not sister corporation entity, not any of these other things. I mean, they spent hundreds of thousands in litigation on this. They should have spent it on the contract. If this is their intention, they should have spelled it out. Instead, they said, here you go, get out of here. You weren't harassed. Have a nice day. Okay, well, what am I supposed to do except for interpret that contract within the four corners of the document? I've never been back to any units affiliated with owner. And further, how am I supposed to know the complicated ownership structure of this organization? It's not a publicly traded company. So I'm just saying, listen, if that's, even if I concede all those points, it still doesn't preclude me from having the rent stabilization rights associated with requesting a lease in a hotel, and it doesn't preclude me getting the due process rights of an eviction. To be thrown out into the streets with no due process rights, I mean, that's the really important issue here. Otherwise, we're gonna have judges just going around saying, oh, it's contempt, throw them in the street. And I don't think that that's what anybody wants.
But you were ejected from the unit that you were occupying, correct?
The court issued an unlawful order based on contempt.
This is the Marcel Hotel.
That's because you failed to pay the use and occupancy at that particular hotel.
Correct. So the court ordered use and occupancy under $3,700 using no known formula for calculating that.
Right.
Single room occupancy apartments generally, if they were $350 or less in 1969, I've done the math.
But that was prospective. That was for the time that you were using it, right, into the future. And you, according to the court, since you failed to pay and comply with that court order, you were in contempt of the court order to pay use and occupancy. And so the court issued an order ejecting you from the premises. This had nothing to do with the surrender agreement, did it?
I agree with you. And the issue on that is that the building didn't have a valid certificate of occupancy. No rent was due, nor did they have the apartment.
But it had nothing to do with the surrender.
It had nothing to do with the surrender.
Correct. It had nothing to do with surrender.
Isn't use and occupancy a discretionary determination by that judge?
At times it can be, unless the defense is raised. There's like 4 defenses that can be raised. One of them is use and occupancy. The other one is failure to register the apartments. A third one is...
It's okay, we know. Thank you.
Yeah.
We got it. Yeah, your apprentice.
Good afternoon, Your Honors. May it please the court, Scott Lafredo, Belkin, Bird, and Goldman for the respondents, Alibaba Hotel Corp. And East Side Inn, LLC.
Alibaba and their attorneys drafted this surrender agreement?
Yes.
And if it's ambiguous, that would work against you? Maybe you should have defined affiliate a little bit more clearly?
If the court found that it was an ambiguous agreement, but I think the last couple of minutes reveals that it wasn't ambiguous. Affiliated with is intentionally broad language, that the agreement is expanding the universe beyond just the property address.
Right, but he states that how would he know what would be an affiliated entity of Alibaba? How would he know that?
Two ways. One is, in the record, Mr. Podolsky submitted an affidavit explaining that it was informed to Mr. Prose at the time it was signed that the Marcel was an affiliated hotel. Two, Mr. Podolsky negotiated the entire surrender with Mr. Prose for hours at the Amsterdam. Mr. Prose was residing elsewhere at the time. He wasn't actually residing in this hotel. That's in the record. He was residing in Brooklyn. Once he returns to the Marcel, he runs into same exact man, Mr. Podolsky.
Why wasn't the Marcel, if he was told when he was negotiating this surrender agreement, why wasn't that included in this surrender agreement?
The agreement states that Mr. Prose is barred from not only entering the Amsterdam, but any hotels affiliated with the Amsterdam. That gets to the larger picture.
Any hotel?
Amsterdam?
The Amsterdam court was the first hotel.
Oh, right, okay.
That Mr. Prose was paid $100,000. And he would have this court believe you that he was paid that money so that he could literally walk out the door, walk next door to a sister hotel, and do the same thing. Mr. Prose has used this claim to rent regulation, and I'll borrow a phrase that's been used before, Your Honor, recently, as pretextual, because he goes from hotel to hotel to hotel as a pretext and demands money in exchange for leaving. It's in the record that he's admitted to doing that. He did it at the Amsterdam. He then went somewhere else in Brooklyn. He lost at the Appellate Division after 2 years of litigation. He then came to the Marcel. He didn't pay a cent of use and occupancy for 3 years before this case was commenced. He was told immediately upon entering the Marcel, if you didn't know then, you know now. I gave you the $100,000. Mr. Podolsky is saying this is affiliated with the Amsterdam. And Mr. Prose said, well, not only am I not leaving, but I'm going to call a friend that I know from way back when, Mr. Kapadia, and he's going to call 2 friends, and then he's going to call another friend. They took over 5 separate units in this hotel, and they each demanded 6 figures to leave. I'm not guessing that. It's not anyway. We know this because the co-plaintiffs of his, the co-conspirators, Mr. Kapadia, Mr. Correa, and Ms. Herrera all submitted affidavits telling us of this scheme once they were confronted with Judge Bannon's righteous use and occupancy order directing them to pay for their hotel rooms, which they weren't even living in. They were out of state.
So when he moved, when he got a room at the Marcel, he was told, this hotel is affiliated with Alibaba.
The second time.
Yes.
What was the first time?
The first time was at the time when he executed the agreement with the Amsterdam. That is in the record. That is in the J. Podolsky
And he was
affidavit.
specifically told Marcel is a part of.
Yes. Now, and even if we were to assume that didn't happen, again, he walks into the hotel, he meets the person who gave him $100,000 2 years ago, and the person says, you don't remember me? We're affiliated. Now, this wasn't just...
But now this comes back to what is the phrase affiliated with owner?
Yes. The Business Corporation Law 912A1 defines affiliated with as a corporation related to another by common shareholding control, means, and operation.
Interesting, because he just stated that it wasn't publicly traded.
Mr. Prose is a man of many talents. His one is extorting buyouts from hotel owners around the city. He's actually in litigation right now doing the same exact thing.
Well, that's not a part of the record, but I'm just saying that he specifically stated, how would I know that they were an affiliated entity if it's not publicly traded? He said that.
And I just explained that he was told at the time of signing as well as the time he entered into. I want to get to 2 points really quick as my time's expiring. The Business Corporation defines affiliation. If Mr. Prose wants to create a new definition of affiliation in his head to get around his contractual obligations, that's surely his prerogative, but it doesn't seem to be picking up much traction. It didn't pick up much traction with Judge Bannon, who was not pleased. Judge Bannon ordered Mr. Prose and the 5 other individuals to pay prospective use and occupancy, not even for the 3 years they were residing in the hotel, for 0. She took a number based on their agreed upon rate, which the law provides for, and she split it in half. He should have been paying $8,600 a month. The judge ordered him to pay $3,700 a month, looking forward only. He ignored the order. And this case is on all fours with Marlborough, which Justice Higgins sat on the panel of, where the court explicitly went out of its way sua sponte to direct a respondent to pay use and occupancy at pain of ejection. Justice Bannon's September order told Mr. Prose and the other defendants, you are to pay this money or you will be ejected. They completely ignored it. 4 of them got scared. 3 of them gave us an affidavit explaining what he's doing and left. And Mr. Prose is the one who stayed behind. He's actively at another hotel now. You can look at it on NICEF doing the same exact thing. Bruen versus Cole, Appellate Division, First Department. Regulatory protection should not be available when a tenant's claim for protection is based on less than a need for a place to call home. Mr. Prose is making a living out of extorting buyouts by pretextualizing a statute for units that were built pre-1969. All 5 of these units were built in 2007. Thank you.
Just real quick, I do need a place to call home. That's why I lived at the Marcel for 3 years. But as Councilor Lafredo just said,
You lived at the Marcel for 3 years without paying any rent or use and occupancy, correct?
the rent was never calculated by the DHCR.
And another question, when you rented there, were you told that that hotel was affiliated with the Amsterdam or Alibaba Corp?
Jay Podolsky showed up and said that I can have whatever I want. That's what he said to the manager.
Take whatever you want here.
He said, don't harass this guy. 6, 7 months later, we meet again. He tells me, I got to answer because I'm in default. But you can't build new SRO units. Administrative Code 27-2077. He said they built them in 2007. You're not allowed to build new units since like 1988. So, but yeah, a lot of ugly language about me as a person, not a lot of things about the law. I think that maybe the question of affiliation is up to this court to decide, but my understanding of that contract, my intention as a person who was party to it, was that I'm leaving the Amsterdam Court Hotel forever, and I'm waiving my rights to the harassment claims, and that is it. It's not waiving all of my rights to request leases in hotels in the future. And, I still need to live in a hotel now, and so I do. And it's my right.
Thank you.
Thank you.